It's bigger than you. It's bigger than me. It's bigger than you. It's bigger than all. It's bigger than me. Bigger than you. It's bigger than all. It's bigger than me. Bigger than you. It's bigger than all.
Hush! Now I'm trying to have court. You don't raise your voice again.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican boys, verbis Latino.
That's literally not true.
Oh, for crumb's sake.
Is that correct?
I didn't ask you to interrupt me.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Hope your lunch was fantastic today. We're about to get back to the Donna Adelson trial, where we anticipate defense is putting the final touches on their closing arguments. Just dotting a few T's and crossing a few I's, as they have done throughout this trial. But yes, I said that intentionally in that order. But a couple of you just having dinner. Teresa, that's wonderful. Let's see, a big shout out to Kim. Kim, thank you very much, Kim. Kim was first in chat this afternoon, which means that we recognize her for her promptness and then punish her as well. Punish her for being first in chat. Everything IP related worldwide is your responsibility, Kim, but you seem to be taking it on the chin, and you promptly gifted a membership as well. So it looks like you're capable of handling the internet as well as, giving some gifts at the same time. So Kim and AWOL Podcast, thank you very much for your generosity, both of you. Going back to, let's see, they probably only wrote their closing on lunch. I'm just putting it out there, they probably just need a moment. When we come back, the jury said, Judge, if we could just have a moment, I need to go over a few things with my client, and then I was going to start writing my closing, Your Honor. If we could just have just a few minutes to do that. We just haven't, the trial's been so busy. We've been so busy handling everything else, with the witness that wasn't a witness at the jail, and not talking to Donna about whether or not she was going to testify. We just haven't had time to really sit down, take it all in, review it, and then organize our thoughts. So just a couple more minutes, and it will be ready, Judge. Maybe you thinking maybe tomorrow morning might work for you? No, 5 minutes? Okay, that'll work for us. Tumwater Troy gifted a membership as well. Thank you, Troy. We're going to be headed up to Tumwater, Washington as soon as the verdict starts, because we've got a recording of something that went down up there with a pro se defendant, which might drive you to insanity. I admit, it might drive you insane. But this guy's a little different than some of the pro se guys we've seen. So we'll see that in a little bit. All right. If everyone watching clicks the like button, we may unlock all Greener's banned chats before he gets here. Camilla, my kids went to the post office and picked up a package. You sent a stuffed goat for my future-to-be grandson or granddaughter, whichever it is. Thank you very much for that. We're gonna ship it across the country with my son, who is headed out there in about a week. So it'll be there waiting for the first stuffed animal for the grandchild. D nice. I'm not sure exactly where we're gonna go next. I know there's a sentencing tomorrow we may watch. We've got a couple things in the works, but we usually don't focus on that until this one's over. We like to stay focused, like locked in. So, plus I like to have it a surprise because I'm indecisive and I struggle with, I go to Baskin Robbins, they have 31 flavors, and I'll be there all day trying samples, and even then I don't know what I want. So, it's a grandson. I told you this already. Holly, I'm thinking it might be, I don't know, name him after me. So, is this pro se worse than Brooks? No. So the thing is, Brooks was pro se and a little soft sit, but he didn't understand the arguments. He didn't understand the theory, the background, the basis for his arguments. This guy does. So he's able to at least articulate a little bit better his arguments, but it's going to be fun. So yes, grandbaby on the way, but it's a couple months off. So by couple, I mean April. Could be as late as April. And we're super excited about that. It'll be our first. And for both sets of grandparents, or great-grandparents, as the case may be, it will be their first. So it will make my parents, great-grandparents, and my my wife's, and on the other side of the family. I think it's like a first all around. It's really cool. We're really excited about this. Lone Star Cross Stitcher, new to the channel. So happy about the news about your first grandbaby. I am as well. You want to name your grandson Recovery Addict? Well, I'm okay with that being two middle names. No, that would be terrible. That's terrible. I would not do that. Nor will they let me. Robin gifted a membership. Thank you, Robin. Very generous. How did your son and daughter-in-law end up in Idaho? She was raised there, and he went to school up there. And that's where they met, at school. Let's see. I have an ancestor with the first name Ransom. Wow. That's pretty cool. I have an ancestor that was put to death for getting drunk and getting in a knife fight and killing the king's guard. And he was beheaded by the traveling executioner. It's amazing stories you can find in your family history, looking back a few generations. Got some great stuff. There's a fun story. It's not very fun. I can look at it and sort of laugh and say, oh, that's cool. But the idea was, if you were sentenced to death, since this is a true crime channel, we can talk about this. This is in Norway, by the way. Ancestors in Norway. And my ancestor apparently liked to imbibe a little bit in the local beverages. And at the pub, drank a little bit, got in a fight, and may have stabbed a fellow patron of the bar who was a guard for the king in the stomach, and the guy died eventually. Terrible, terrible tragedy. It happens. Judge found him guilty, and he's sentenced to death. But apparently all the small towns, like every town has their mayor or their little local, rulers and the police constable or whatever, the positions they have. But not every town can afford their own executioner. And so you have to get together with other towns and sort of collectively rent one or buy one, and then they have to travel around. And the executioner brings their own equipment. So they've got their own, like the axe and hood. I guess you have to wear the hood when you use the axe. And so he used the sword back there. They didn't use the axe like traditional, you think. It was a sword that they used. And so the executioner is coming to town, and as he's coming to the church, which is where they did executions, because, why not? I mean, the graveyard's right there. It's convenient. It's like one and done, buried, done. It's quicker. He's coming to the church. As he's coming to the church, there's a family with a newborn baby that is leaving the church, having just had the baby named or whatever, the thing they do. And so the executioner and the family meet on the road, and it's like, do. It's like a show. No, it's not a showdown, but by tradition, if this ever were to happen, which apparently it's happened before, the executioner swings the sword over the bassinet that the baby's in. Yeah, I'm not making this up. It's like, here's a good idea. Hey, try this. Wave your killer blade over our new child, our infant. And if the blade whistles as it goes over, then it means that the guy he's about to execute is going to get saved and go to heaven. And if it makes no sound, he's down to Hades he goes. Well, good news for my ancestor. It whistled. And then he got beheaded and he was buried in the graveyard. So that's the end of the story. So I thought you might enjoy that. Welcome. Hope you guys had a great lunch. This is all found in, I don't know what it's called, a big book or something. It's some of these town books that are records that are kept years back in Norway. Pretty cool. Anyway, this is the sort of thing you can expect when you come to my channel. A lot of non-relevant stuff, and the podcast, the Not Relevant podcast tonight, 8:00. Join us for that. It's going to be great. What part of Idaho? I think they were in Rexburg, and then they went to like somewhere else that's like half an hour away or something. I don't know. Yes, tonight, 8 p.m. on the channel. We'll talk. We'll hang out. We'll talk and be here. It's live. It's a fun podcast. In our third season and something like 32nd episode, I might add. So we're already in the top, I don't know, 1% of podcasts as far as just pure sticking power. I'm not saying anything about quality, but just, we haven't given up yet. So it's good. Norway is a country where jury duty started more than 1,000 years ago, and they still have court docs from that time. Cool stuff. They have amazing records, although they guard them closely. Some of the records, historical records, my mom purchased some, like a set of books that had historical records for towns, and major family history-oriented organizations talked to my mom into scanning those copies of these extinct books. And so a lot of that history is because my mom had the books. And so now that's digitized and everything else. But Norway does not like giving out information unless you're a Norwegian citizen. And so if you have ancestry that goes back to Norway and you're trying to see like if you're related to some king or somebody cool that might have some money waiting for you, you sort of have to find a Norwegian citizen who can research that for you because no one else can get it. So anyway, what is the podcast about? The podcast is called the Not Relevant Podcast. We look at it as all day, every day. We basically talk about murder, right, on this channel. That's pretty much our go-to as far as cases. Basically the worst of society, what the meanest and cruelest of people do to each other. That could get a little heavy, and we recognize that day in and day out. We know that it's helpful to have some light breaks, and so we focus on lighter stuff generally, usually not court cases, some fun news, some funny things, some fun stories, personal stuff, and we do it live in front of a live audience, you guys, and you guys participate and suggest stuff, and sometimes our suggestion never gets around to being raised, and your stuff is all we talk about all evening. So it'd be fun. Join us. Once you go, you'll know. And like 8 out of 10 people don't regret watching the podcast. We do a few dad jokes. All right. I think Runkle has family in Norway as well. That's awesome. Let's see. Oh, yes, and we also give out memberships. Thank you, Heather from Texas. Today we'll give out 10 gifted memberships because YouTube has them allotted for me to give out, and we'll do that. Usually first thing, so like the first people to show up at the podcast are more likely to receive a membership, but it's not necessarily that way. YouTube still chooses. We'll give those away, so be there. Two out of 10 people regret and unsubscribe. But it's all good. All right, we're about to come back in just a few minutes to court where the prosecution has already provided 1 hour and 53 minutes of their 2-hour closing. They only have 7 minutes and 6 seconds left. I'm going to make a new timer. So we have one for prosecution and one for defense. We'll do a countdown because it's a little confusing when it counts up. Everyone's like, what's the ending? Online timer. Here we go. It's going to be a full 2 hours, although I think they will not be using it. Okay. And where's my super source? There it is. Okay. It's going to look like this. We'll start a timer when the defense takes the stand and see if our clock and the judge's clock match up at the end of the day. Lindsay Ross says, I told my mother-in-law about your channel. Now she loves the channel and podcast. Even better, we chat in the chat. Lindsay, that's awesome. Shout out to your mother-in-law. Lindsay's mother-in-law, welcome. Thank you. Appreciate it. A pain in the rebuttal. I think they're going to need more than 7 minutes. There's a little flexibility. I think because the judge said this case was supposed to go 3 weeks, and we're here on a Thursday, and they're basically handing it to the jury, we are ahead of schedule. But he's not going to be like, oh, yeah, you get an extra hour. That's not going to happen. Should have caffeine to deal with this closing. I don't know. I don't think it's going to be as long as Georgia's. And she's got to inject some feeling. We, my family, are from Ostervold Island, Norway. Ostervold's English. The English where? Peter, where? I say Norwegian. I've told this story before. I thought I was Norwegian. Like I just shared a story of my ancestor from Norway. I thought that was true. It happened. All of it happened. Like I found out that I'm not as Norwegian as I thought I was. Like all that ancestry line, I don't think I'm actually even connected to the guy. Even though on paper we were for a while. What happened was my grandma and grandpa. My grandpa was amazing. He was like an artist. He drew stuff. He drew like trolls, and he'd carve wood blocks into these Norwegian mythical trolls and things like that. Amazing guy. Great artwork. My grandma would paint amazing fancy Norwegian designs and stuff on stuff. Anyway, fun things. My grandma and grandpa got married fairly young. The day they got married, my grandpa went out and joined the Merchant Marines for 2 years. And when he came back, my grandma had like a 2-month-old daughter who was my mom. So a little math will tell you that that the timeline did not match right. It didn't. The daughter should not have been 2 months old after the husband has been gone for 2 years. So it was only a few years ago that I found out that I, in fact, am more Welsh than I am Norwegian, and that there was a hairdresser in Wales who did more than just get you a nice cut, a nice do. There was more doing to the do than that. So got some Welsh in me as well, but don't tell my my Norwegian relatives because I think honestly some of them don't know yet. So there's that. If they're watching now, now you do. Sorry. That happened. All right. I had a great lunch. How was your lunch, everybody? It was great. How do we call Burner if we're deleted in error? Kim, if your comment was deleted in error, all you do is you just understand that the mods are human, and a lot of times chat goes really fast, and it happens. Very rarely, like I don't think I've seen maybe one in the last month, one person has actually been removed from the channel. It's even somebody who says a comment like a Greeners who might mouth off a little bit or say something you shouldn't. Even if the comment gets deleted, we say, that's a little too far. That's a little too edgy for our group. We might chuckle a little bit under our breath, but say, we can't have that there. We ask them to sort of step back in line, and it's all good. The mods are incredibly patient. I mean, don't test their patience, but they are incredibly patient. And if something got deleted on an accident, just realize that it was probably a mistake and it was probably my fault. So don't blame the mods for that. If you think there's a problem, an issue, or something that's bigger than that, if you think you've been hidden on the channel, no one can see my comments, you might have done something wrong. We can go back and look. I can look at everything you've ever done that was moderated on the channel and see exactly what you said. So YouTube gives us receipts, and I can do that, and we can look at it and say, oh yeah, that was a mistake, and I can fix it. That's why we have the burner phone. So feel free to call me on the burner phone. It's all good. Kim, thank you very much for the super chat. Appreciate it. Let's see. Still waiting for lunch to be over. I think we've got about 4 minutes before they're going to start. All right. Feel bad for the Chuck E. Cheese guy. Anna Banana, this is funny. If you haven't followed this, there was a Chuck E. Cheese mascot, an employee at Chuck E. Cheese wearing the whole outfit. Who was like, "Hey kids, it's time to sing." That guy, right? That was arrested and cuffed in a costume and let out of Chuck E. Cheese. He is going to court and will have to face the judge. And that judge is none other than our own very Judge Everett from this court case. Can you imagine? I hope this gets televised. I really do. But Chuck E. Cheese will be here with Judge Everett in this courtroom, and probably very soon after this case is over. For stealing credit cards. Yeah, I mean, it's not like he's like, I gave away too many tickets at the booth or something. No, it's a bigger thing. Justice for Chucky. Yeah. Face the judge in outfit. No, that you probably won't recognize him. But there's a video. There's a FOIA request that got the video out. So you'll see. I think even Fox News ran it or something. It's been around. We are doing the podcast tonight at 8 p.m. Hopefully it won't be a verdict podcast. But all right. I don't know if he's going to plead guilty or not. I'm not sure if there's going to be a deal offered. I don't know if he's going to go to trial and jury or whatever else. If he goes to trial, that arrest is going to be full on camera. It's going to be shared. It's going to be good. All right. Burner isn't working. There it is. It's right here. There's the burner number if somebody needs it. That is a phone line directly to me. Obviously, I'd ask you not to abuse it because I do answer day or night, usually when that calls. As long as I'm not doing something else that's extremely pressing, like talking to Mrs. R.A., we'll take your calls, and sometimes we put them on the air. So we ask you just to keep all conversation on that phone respectful, as you would. And that way I can keep granting you guys direct access to me, and we can all get along just fine. All right. You have an answer at 2 a.m. There have been times I have, Josh. I will tell you that Amber was up at 4 a.m. Amber?
The ones that are in evidence, yes.
It's not in evidence.
It's not just the ones that are in evidence, Your Honors. It's also the other ones that we had requested to be put in evidence and submitted as court exhibits.
Well, these are items that are not in evidence. I believe the state's demonstrative specifically dealt with items that were in evidence as a part of its closing presentation.
I don't dispute that, Your Honor.
For anything that is not admitted at this time, it cannot be presented to the jury at this point as evidence for consideration or argument for consideration. The pages of the two calendars that are in evidence, you certainly can use. You can use the physical books themselves as demonstratives if you want to show the jury. Beyond that, getting into pages that have not been admitted and are not a part of evidence, what would be the proper basis of doing those?
Again, Your Honor, the way in which it's been presented is misleading. My client has, even if it's not a specific basis for admission of the rules of evidence, the Constitution allows my client to present evidence in support of her defense, and just based on, as I said, the way that the state has misrepresented items in the calendar, we would like to be able to present that as argument to the jury.
Again, at this stage, for items that are not in evidence, I do not find that these are specifically exculpatory. You can make any reasonable argument or inference as it relates to the admitted evidence, but items that were never admitted at this point are not to be presented to the jury.
Yes, sir.
That is like lawyering 101. Judge, can we use stuff that's not evidence in our closing? And judge says, no, it's not evidence. It hasn't been admitted. But we want to, Judge. No, you still can't. But the state used stuff. All of that was in evidence. But we want to use other stuff. No, you still can't. That deserves a goat scream on its own. my goodness. So now they're going to need a few minutes to take those parts out of their presentation. Kim, thanks for the gifted membership.
Your Honor, since we don't have a beautiful presentation as a state while Ms. Fulfer is giving the closing, I will be assisting by putting the items on display.
That's fine.
All right. Sort of tag team, but only one person talking. Apparently they didn't have time to make a PowerPoint. Why does it look like they're just gathering stuff now? Like, why is it not done and ready to go? This could be a train wreck. You guys, if you don't have a screaming goat, you need to get one. They make life better, honestly. They really do. I think they're good for the soul. They're good for the brain. It relieves stress. It's well worth, I don't know what, $8 to $12 they cost. And of course, you can use our Amazon link, Amazon affiliate link, and then a couple cents from your purchase. Doesn't add to your purchase, but a couple cents from your purchase will be returned back to us as a thank you from Amazon for bringing you to them. So, full disclosure. She needs a dog clicker to make him change the poster board. Oh, can you imagine that? A little shock collar. Like a zap. Oh, I'm on it. Zap. That could happen. It looks like that because they are just gathering stuff now.
All right, jury entering the courtroom.
Just whatever you do, don't drag the podium around anymore. Just leave it right where it is.
Everyone can be seated. Members of the jury, I hope you enjoyed your lunch break. At this time, we are going to continue with the defense's closing. Defense, you may proceed.
Good afternoon. It's been a long day. You've heard a lot, but I hope you'll stay awake so you can hear me too, okay? So, it's been what, 2.5 weeks, I guess, since you started this venture with us, and you've heard an awful lot. And I'd like to take you back to my opening statement. In my opening statement, there were some things referred to today that I'd like to address. The first one is that I stood up in my opening statement and said all of these wonderful things about Dan Markel, and then I called witnesses to attack him. That is not true. That is not true. In fact, the defense is the only part of this case that actually elicited evidence through testimony about the good qualities of Dan Markel. We elicited that on cross from his ex-wife, Wendy. And all of the things I told you in opening about what a wonderful man he was, a wonderful father, well-educated, successful, we elicited that testimony. And criticized today for having 2 witnesses who came and testified on the stand about the dissolution case and things that had been filed in it. That was not to attack Danny Markel. We didn't put that evidence on. The state is the one that made it an issue. They put those documents into evidence, the things that Mr. Markel had filed. So we're the defense, and we represent Donna, Adelson, and we're just supposed to say, okay, well, they've put it in, let's just let it sit there. We have an obligation to represent our client, and what happened in that divorce, whether it was contentious or not, was an issue the state brought up. They've been calling this a bitter custody battle for years, and they started this case by saying the same thing. So to have the people who were actually involved in the case point out that there never was a bitter custody battle is important, because there never was one. There was never a time when they were fighting over somebody having access to the children. In those pleadings, nobody says, you can't have them, I've got them. You can't have them, I've got them. When they filed their initial pleadings, they did what everybody, according to the lawyer who was on the case for Mrs. Adelson, meaning Wendy, on the case for Wendy, they all filed their typical pleadings. And in the beginning, you ask for certain stuff, and she asked for 5149, maybe for a tax purpose. But there was never one single time, and you can't be convinced that relocation was the issue where they were going to take Danny Markel's kids away from them. If you believe that, you are ignoring the evidence that the state of Florida put on against Donna Adelson. And when I told you in opening that this was all about theory and belief of what a motive was, and there was no evidence that a crime was committed by my client, Donna Adelson, that is exactly what has happened in this courtroom. The state is ignoring the evidence that came in through their witnesses that support our defense, and instead they stand before you with calls and text messages, and they tell you what they mean. That's not evidence. Their argument about what a conversation means is not evidence. You decide what it means. You've got it in front of you, and you have to consider it in the context of all of the evidence that's presented. Not just what the state puts in, but what the defense puts in. And I know at some point when we were putting on evidence, you all were looking probably at me like, what are you doing? Who cares? Some of those little things matter, and I'm going to cover those in the defense, and you'll see why we put those things in that didn't seem like that had a hoot to do with anything, because they actually did. Now,
she's yelling at the jury.
I think the state, near the beginning of the case, and I don't recall who the witness was, but near the beginning of the case, the state, through a law enforcement officer, elicited testimony about how this event transpired, this brutal killing of Danny Markel, how it transpired, and how they were able to break the case. And what did they tell you? They told you they broke the case because Luis Rivera, who was one of the killers, decided he would cooperate with the state of Florida in exchange for a deal, which for his crime, he ended up, the testimony was, he got 7 more years for committing that crime. This is the man who got in the car, got the gun off the street, drove up to Tallahassee, Florida, stalked, is the best way I can describe it, Danny Markel in a car with his children from his home, watched him take his little boys out of his car and put them into the daycare center, followed him again to where he went to work out at Premier Gym, and sat in wait for him. Sat in wait for him. And then when Mr. Markel came out, trying to work some things out with his ex-wife Wendy about having the kids and who's picking them up at what time, even leaves her a really nice voicemail that they could get together and walk at the school to talk about the education of their older child, where he was going to be going to school because he was going to be starting kindergarten. And Wendy pushed back. You know, she pushed back. This was his time with his little boys, and she's telling him no. You know, I've got plans. Well, it wasn't her time to do that. So leading up to his death, she's arguing with him over about an hour and a half worth of time that she thinks she's entitled to with the kids, but it's his time. And I agree with the state of Florida. The most important thing to that man was those little boys. And he fought for every minute he could get, and rightfully so. Then he drives home in his car while he's on the phone, and Luis Rivera, driving the car that's been stalking him all day, pulls up behind him in his driveway. Sigfredo Garcia gets out and shoots him twice in the head, and they pull off at a pretty high rate of speed and leave Danny Markel dying inside his garage. Left him to die. Those are the people that killed Danny Markel. Those two people. And the state has all kinds of arguments about how Mrs. Adelson's involved because she said these things about him, and we'll get to that in a second. But if Luis Rivera is telling the truth, what did he tell you when he got on the stand? What did he tell you? He said, and this is his signature on this document dated March 11th, 2025, when he was deposed, and those numbers and circles are his. And he testified to you that, where are my numbers? That Catherine Magbanawa, that's right, Catherine Magbanawa is the person that elicited Sigfredo Garcia to kill Danny Markel. Now her versions change over time, so we'll have to address a few of those. And then she says she didn't even know Luis Rivera was involved. This is a woman who the state has admitted lied first time, second time, third time, fourth time, maybe the fifth time. Every time she puts herself under oath and swears to tell the truth, she's going to say more. She told you she didn't even know Luis Rivera was involved, but the phone records that were put in by the state of Florida prove otherwise. Because during the time that they're traveling to Tallahassee, when she can't reach Sigfredo Garcia, whose phone is she calling? She's calling Luis Rivera. This woman can't tell the truth. But in any event, Luis Rivera then puts this number 2 next to Sigfredo Garcia because he's the one who actually killed Danny Markel. Number 3 next to himself because he's the one who got the gun and drove the car to kill Danny Markel and then away from the scene. This is the man that he says they killed. Who else on this document do you recognize? On this exhibit? Who else? Who else was involved in this? Well, all the players that the state claims are involved are pictured on this document, and he says, Wendy Adelson, she's the lady who wanted to get her kids back. This is why we were committing the crime. Wendy Adelson. And Doctor, the dentist, he called him, which is Charlie Adelson, who he identified, was the one with Katie. This one and this one are the reasons that they're coming to Tallahassee to kill Dan Markel. And I said, well, what about Donna Adelson or Harvey Adelson? No, they weren't involved. I said, would you put an X next to them if they weren't involved? And he did. Donna Adelson's name never came up, but Luis Rivera is telling the truth according to the state. That's who you're supposed to believe, and he says my client is not involved.
Charlie says she is.
There's some issues that I might address further, but I want to go through some of the things that the state stood up and told you. Relocation, 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 that's the issue. That is the reason that my client had Danny Markel killed, because relocation was lost. Danny Markel was killed July the 18th of 2014. Relocation was done for over a year. That's the motive? It's been over for a year, and they said yesterday in court that the relocation issue didn't stop when Danny Markel was, when the divorce was over. It continued going on. The emails showed that. There is not a single email that's been put in by the state that shows that my client, Donna Adelson, was continuing on a rampage about relocation. The last email that they showed you today that my client wrote about relocation was July the 19th of 2013. The divorce was final on the 31st, said and done. They bring Wendy Adelson in here to testify. That's their witness. And she said it was done. Now, have Charlie Adelson and Wendy Adelson been honest with their mother? The evidence says no, they haven't been. Because the whole time Wendy Adelson is telling her mother, she's telling her mother that relocation is what she wants. She's the one who starts that. She's the one who asks her lawyer about it. The whole time in the spring leading up to this hearing, Wendy Adelson admitted in her testimony she's sending these messages to her life coach and telling her life coach, you know, I think I want to stay in Tallahassee. But she didn't bother to tell her mother that. Her mother still thinks she's trying to get relocation. She does it in April. And then she writes to her again in May. I think I'm going to give up relocation. I can stay in Tallahassee. The kids will be close to their boys. There won't be any plane rides. And I like my job. It gives me all this flexibility. I'm going to stay. But she still doesn't tell her mother. She has her mother believing we got to fight for this relocation. She testified Well, I said, why did your mother get so upset? Well, she's venting to her mother about what she claims Danny Markel is doing, and she's venting to her mother about what she wants to accomplish, only she's not being honest with her. On the backside, she's making other plans. It'd have been nice for my client, Donna Adelson, to know that, because these emails that have been submitted here, which are proof that she wanted to have Danny Markel killed, would not have been written. And when she goes to her hearing on the relocation in June of 2013, she has her mother stay outside. Her mother can't hear what's going on in the hearing. She admitted she had several witnesses to call beyond the two that got on the stand. And then after the judge made the comment, she gave up. She could have continued with the hearing and put her witnesses on. The judge could have ruled against her, and then maybe she has an appellate issue. She gave up because she didn't want it anymore, but she didn't tell her mother that. When she told her mother, well, this is how the judges ruled, the mother understood that through the court system it was done, but not with her daughter, Wendy. Because you can continue to negotiate all the way through a final judgment. And that's what those emails say. They do suggest some crazy stuff. They do. But she puts in there, we're trying to negotiate. We're trying to negotiate. Get this, you can still work on this. She doesn't know when she's writing those crazy emails that there's no reason to write them because her daughter agreed. You know, you can have a dismissal on an issue. You can have a denial on an issue. She agreed to it with prejudice, which means it is over. She already made an agreement. She's not going to seek relocation anymore. So my client is hanging out there trying to support her daughter, and now she's sitting in a court of law charged with murder because of what she wrote in emails. Because the truth is, you are here to judge my client based on her conduct leading up to and to the time of death of Danny Markel. That's her conduct. Can you consider things she said and did after to see if it corroborates that she was involved? You can. But her conduct leading up to the day that Danny was murdered is in this book that the state has entered with emails. It's separated between, where you can see it, where they lead up to the divorce and then after the divorce until the time of the homicide. Now, my client did say ugly things about Danny Markel. During the divorce, she did. And the state has put them in. This is State's Exhibit 64. And they have emails.
Sorry, Stacy, didn't mean to miss this one.
Going up through July the 11th of 2014. These are the bad names that my client called Danny Markel.
Let's have a sheet.
During the course of a divorce where her daughter is constantly venting to her about what she says Danny is doing.
This is the
she
only
says some
PowerPoint
really
page
bad
they can
names,
make.
and I'm going to say them, although you shouldn't say bad words in court. She called him some ugly stuff. The first one that they wanted to put in was from 2011. He was killed in 2014. They introduced this email from March the 28th of 2011 at 64A, and inside that email they claim shows the hatred for Danny Markel. And you want to know why? According to their exhibit list here, because Mrs. Adelson referred to Danny's parents as, quote, the royal couple. And she and Wendy were bantering back and forth about some issues with Mr. Markel's parents. That's not hatred on Danny. It's not even hatred on his parents. We're sitting here with murder charges because she did something like that, called somebody a royal couple. She said other bad things. She called Danny a major fucker, Gibbers, which Wendy Adelson testified that she came up with that nickname for him, a religious zealot, and Wendy testified that the issues in their marriage included matters of he had now become more strict in their religion than she wanted to follow. That was one of their problems. She called him a royal jackass, a piece of shit, a fucker, crazy, a bastard, and she called him Elvis. That's why we are sitting here today. That is hatred for somebody.
Elvis.
That proves they wanted to have him killed. Are you serious? You call somebody some bad names and that means you wanted them dead? My client has lack of any ability to stop herself from saying things. She can't do it. And I'm not trying to be offensive to her, but she can't. And all of these emails that they have introduced prove it. She is not a one-word person.
Testify.
She goes on and on and on and on. And they believe that she had Danny Markel murdered because she said some bad words. There's not a lick of evidence in here that they submitted of what she did prior to July the 18th, 2014, where she said not a single word, that she wanted him killed, she was planning to have him killed, she was going to find somebody to kill him, she was going to pay somebody to kill him, she was going to kill him, that she was glad he was dead. That's not in here. And this is it. This is it. Before he was killed. You're judging her conduct before he died, up to his death. And that's all you've got. And I told you that in the opening statement. They have a lot of theories, and they like to spin evidence a certain way to make her look bad because she said ugly things. That is not proof of somebody having somebody killed. And that's it.
She's mad.
Besides the relocation issue, which has been dead for over a year before he's killed, bad choice of words, I apologize.
Yes, it was.
It had ended over a year before he was killed. Now they want to bring in something called the grandmother motion. This is what had to push her over the edge. Their own witnesses said she didn't know about it. Let's see who testified to that. Wendy testified, her daughter, that she never showed it to her and she never talked to her about it. But then there were two more witnesses for the state, and they were Craig Isom and Jason Newland. And when they testified on cross, they admitted that there was no evidence that that motion had ever been forwarded to my client. Not a single piece of evidence. What if she had gotten it? Do you want to know what it accuses her of? That a 3- and 4-year-old said that they called Abba, that she had called Abba stupid. Stupid. And that drove her over the edge? One, she didn't know about it, but two, somebody claiming you said the word stupid, that's what brings us to murder charges? It's unbelievable. But that's their spin that they want to put on it, because they've got this theory that she's the mastermind. And then they stand up here in their closing and they say, everybody who's been charged in this case, so they want to point at the other one, point at the other one, and point at the other one. No, 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 no. Who is pointing at these people? The state of Florida. The state of Florida is doing the pointing. They're the ones getting the warrants. They're the ones doing the investigation. They're the ones charging people, deciding who they're going to give deals to and not. That's them pointing the finger. That's not my client.
That's them, those people right there.
There's no evidence of that. They bring the charges, they prosecute, they get the convictions, they get people sent off to prison. Not us. What, we're pointing the blame at the killers for killing them? They proved that those are the people who killed them. That's not us pointing the finger. They actually did it, and it's been proven. And we're distancing ourselves from Charlie Adelson? Let me tell you something. They elicited the testimony about Charlie Adelson over our objection, if you happen to remember that. It came in. Charlie Adelson is not on trial. You may be sitting in that jury room thinking, well, Charlie did it, and it sure looks like Wendy did it. That doesn't have an ounce to do with Donna Adelson doing a thing. Not a single thing. If you think he did it, he's been convicted. He admitted in his testimony that he is the person, although he claims he was extorted, he is the person that took $138,000 out of his refrigerator-size safe that he has at his house with the money exactly like he says he kept it, stapling $100 bills together in stacks of 1,000, staple, 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 staple. He said he took that money out of his safe and he gave it to Catherine Magbanowa that night.
And that
whether
his mom
that's his
watched it.
girlfriend and they're still fooling around on the side, that's between the two of them. That's got nothing to do with my client. He did it, but now they want to say Donna Adelson did it. Pick one. You don't like our theory? That's what they say. You don't like our theory? Oh, well, you like our theory on everybody else. Pick one. If you have prosecuted Charlie Adelson for paying the $138,000 stapled just like their other witnesses in this case said, why are they now saying Donna Adelson provided the money? Oh, wait. Oh, because Catherine Magbanawa, who's been sentenced to life and is telling her sixth story now, has decided she'd like to see her kid someday. So now she's going to come in and provide information that will help the state prosecute an innocent woman so she can go home to her children. That's what that's about. So she claims that this all goes down. Charlie puts the money, Charlie, not Donna, Charlie puts the money stapled just like she knows he does into her trunk. She drives it the next day to Sigfredo Garcia, her baby daddy. He takes it out of the trunk, and a day or two later, she gets hers back. And she says he puts it in her closet, and to this day, she wants you to believe that that money sat in her closet and she spent it along the way. The records that Miss Hull testified to, showing all her cash deposits, she clearly was doing something with it, right? But to this day, she wants you to believe she has absolutely no idea how much money she had. Never counted it. Really? She must have think y'all was born yesterday. But here's something. She's got this new thing she wants to testify to. That the money was wet, and Charlie told her that Donna had washed it. Her money's wet, that she hasn't touched, that's been somewhere else for these number of days. Well, what did Luis Rivera testify to about his money that he got? He said it was weird. Well, how was it weird? Well, it was stapled in $100 bills, stacks of 1,000. Not a single word about wet, and he got his money before she did. He got it straight from Sigfredo. This washing money wet thing is nonsense, and they've already proven that it was Charlie Adelson's money that was paid through Katie Magbanawa to those two killers. Whoops, it's gone. But now it's her fault.
Just
and
because
I'm
Charlie
not
had
sure
it
what
in the
this
safe
is all about. The
doesn't
state
mean it
standing
didn't
up
come from
saying
Donna.
that the defense has suggested that Harvey is the one that did the Evite. We haven't said a single word, presented any evidence, or made any argument that Harvey Adelson is the one who created the Evite. Their witness that they called, Wendy Adelson, sat up there and said, what did she say? She probably did it because her mom doesn't know how. And then their other witness, Chris Corbett, Sergeant Corbett, who does all the media and cell phone tower stuff, he sat up there and he said it was clear to him from his research and investigation that my client, Donna Adelson, didn't have a clue how to work that. But she's responsible for sending out an Evite that Wendy says she did, where the names come up with guests who are going to be there that are Wendy Adelson, because she kept that name, and her two sons. So it's Wendy, the name of her two sons, and then Adelson at the end. If that's how it appears, Wendy did it, not my client. And there's more proof of that real quick to come. But the Evite thing is a non-issue. I just can't imagine what that is about. The state has argued that between the time the killers came to Tallahassee in June and the time that they came back in July and actually killed Danny Markel, that Catherine Magbanawa said in her testimony that between those two time periods, when she was discussing scenarios with Charlie, he would say he had a call from his mother, step out, have the call, come back in and say, oh, they're stressed, they're stressed. Catherine Magbanawa, not one single time testified to when that occurred, number one. Number two, if you've heard evidence in this case and paid attention, Charlie Adelson is not a one-woman man. He's got lots of girls. She doesn't know if that was really the mother on the phone. She doesn't know who he was talking to or what they were talking about. But she wants to get out of prison.
Georgia yawns.
She's got information she's willing to share now. Charlie's business. There is a slide that the state had in its presentation this morning that they showed to you that shows that Charlie Adelson owned the dental practice up until 2015. Do you remember seeing that slide? Well, here they are again, ignoring the real evidence. They got a theory and they got to spin it some way, but the evidence from their expert witness, Mary Hall, financial investigator, forensic investigator, Mary Hall, she's up here testifying for them, and she says that Charlie Adelson was the owner of the Adelson Institute until 2020. And yet their slide says, oh, he sold it back to his father in 2015. That's not what the evidence is from their own witness. There was some argument from the state about some things that were in Mrs. Adelson's planner in 2023 around the time that Charlie Adelson was convicted, and they apparently were going to flee the country, take flight to a non-extradition country. And there's a notation in there shortly after Charlie is convicted that says cancel disability insurance. They want you to take what they believe that means as they were canceling their insurance because they were going away and never coming back. Could it be? Those were the words that were used. This is not a could it be situation. This is beyond a reasonable doubt. They have nothing other than that notation. Well, could it be that Charlie was convicted and he no longer needed disability insurance because he was going to prison for life? Just as likely. How about this could it be? Could it be in State's Exhibit 142 on the front page that they showed you with this little notation, notify everyone who was invited to the 70th birthday that party is off if that's what HJ decides to do. And that's on June the 13th. Could it be, the state says to you, that if the killing had actually taken place the first time the killers came up, then they'd be canceling the party because Danny would already be dead? What? Does that, where is the proof of any of this? Could that be what it means? This is not could it be. And a birthday present. The birthday present, according to the state, for a 70-year-old man is that they're going to have Danny Markel killed. Happy birthday. Let's have a party. What? There's no birthday present, according to Rob Adelson. Wendy Adelson, who was at the party and who was involved, and there are emails that tell this, involved in helping get a caterer for the party where the man came and cooked paella out on the balcony for everybody, but that's what Charlie decided to give. But you got to read the worst in every single piece of evidence that they present to you. You have to, because that's the only way you can convict, and they want you to convict her. There's no evidence that there was a birthday present to Harvey Adelson to have this man killed. None. But that's their theory, and they're still spinning it. And you gotta ignore the witnesses that they put up there in order to follow their lead into that jury room and convict my client. Let's talk about Rob Adelson. They brought him in here and he got up there and he testified on the stand about allegedly all of these things that he claims his mother said. If you were paying attention by the time we got to cross-examination, what did we learn about Rob Adelson? Well, he's a doctor and he's got little kids, so he's real busy, which is his explanation for why he rarely speaks to his family on the telephone and has, in that time period, only been down to see his family 2 times in a 2.5-year period. And he rarely talks to him on the phone, but somehow Miss Adelson has made all of these comments. This is a guy with an axe to grind, right? He doesn't have any of this information. He's not talking to him. They got him to come for the birthday party, and what was his testimony? He's a busy guy. He flew in the night before the birthday. He was at the birthday party and got up the next morning, packed his bags, and put him and his wife and his kids on an airplane and left because he was busy. He's not hanging out with his family. He's nowhere to be found. Oh, but you got to believe everything he tells you. A huge percentage of the argument of the state was, well, what did Rob say? What did Rob? Rob doesn't have the knowledge of anybody. He's not here. He lives in Albany, New York, and he's not around these people. But let's use her son, who's clearly estranged from the family, to try and bury her. You're smarter than that. So my client has been charged with the murder of Mr. Markel, conspiracy, the planning to commit murder, and solicitation, hiring the hitman that killed. We're going to go through the jury instructions briefly. The judge has already gone through them, but we're going to go through in a minute what actually is there that the state has to prove. And just like I said in opening, what the state thinks happened does not matter. What they believe happened does not matter. What spin they want to put on it does not matter. You can only make your decision based on the evidence presented to you, and up through the time that Dan Markel was killed, that's all they got. She said some ugly things, and oh, she meddles in her children's lives. Meddles in their lives. Gets involved in their divorce. She's a parent. She's just being a parent, not a killer. She's a meddler, not a murderer. They haven't proven that to you. Just like I told you in opening, what they were going to be able to prove, and that what you were going to hear a lot of evidence about, lots of introduction of exhibits was going to come in. They proved that those 2 men killed Danny Markel, that Catherine McDonowall was the one who found the killers, that Charlie Adelson is the one that paid the money. That's it. Oh, and Wendy Adelson is the one who wants to get her kids back. That's why they're killing him. Nothing about Donna Adelson. We sat here for days listening to testimony of witness after witness getting on this stand. Not a single one of them connected my client to Danny Markel's murder. Not one.
Explain the bump. The TV's about 5.
I think the state introduced a couple of exhibits. They would be 64C and F. Sorry, I can't do technology. Somebody has to help me. And these are emails where she's giving her daughter advice on what she should do, preparing for mediation. Oh, how terrible of her. But what they didn't want you to see in this email, you see that highlighted part? If she thinks she's going to have him killed, why is she telling her daughter in mediation, make sure in the final order that he has to pay half of this expense and half of that expense and extracurricular activities and tennis lesson and baseball teams and travel? Well, who cares if they're going to kill him? Why is she writing that? Negotiate. Negotiate. Shame on her getting involved in her daughter's divorce. Negotiate. Let him know that you want him to see his children. And they talk a lot about this bribe. Bribe. This man, they were considering giving him $1 million to relocate because he had already lived in Miami with Wendy. Relocate back to Miami. He taught, according to Wendy, 2 days a week. He could commute by airplane. They were willing to pay for plane tickets, give him money to buy a house, expose his children to a more strict Jewish environment where they had Jewish schools and all kinds of activities and be around more kids, kosher like Danny. Relocation was never about taking those kids away from him. It was, how can we make it happen? You can live in the same city, we can co-parent separately, but be together, be around each other, and all have family support. Shame on them for wanting to help him like that. They act like they were doing something illegal. That's not illegal. You heard the woman testify. It happens a lot in divorces. People offer money to get certain things that they want, or they concede something they're entitled to. But if Mrs. Adelson does it, she must be up to no good. This grandmother motion, I want to point out something to you for just a second. That would be 60JJ. The state calls this the grandmother motion because they're prosecuting grandma. Sounds kind of cool, right? There's this terrible motion, this grandmother motion that was filed against my client, Mrs. Adelson. This pleading is actually entitled, let's see here, Former Husband's Counter Motion for Enforcement of MSA, which is Marriage Settlement Agreement, on Parenting Issues and Motion for Contempt and Sanctions. And this pleading goes on and on about, he says Wendy's refusing to facilitate marriage settlement agreement on parenting issues and motion for contempt and sanctions. And this pleading goes on and on about, he says Wendy's refusing to facilitate video teleconferencing with the 3 and 4-year-old, that she's failing to regularly facilitate telephone contact with the children, that she routinely violates the right of first refusal, resulting in the children missing days from preschool, that she violates her duty to inform that's in the MSA. She fails to follow clinical recommendations. She violates by refusing to communicate with Mr. Markel. She persists in inhibitory parental gatekeeping. Refused to provide access to have both children on one of the child's birthdays. The only single complaint he makes about my client is she called him stupid, according to a 3 and 4-year-old. And I can do this, but I'll try. Number 6. This is the section. You can write a motion and put all your complaints in it and your legal argument, and then you ask for what is the relief that you want. He wants all kind of relief related to Wendy. And this is what they say. The state says that he's saying that the grandmother cannot have any unsupervised contact with the children. That's not what it says at all. It says consistent with the right of first refusal. And safeguard the children so she doesn't call him stupid anymore. This does not mean she can't have unsupervised contact. It means consistent with the right of first refusal. If grandma's in town and she's going to watch the children, according to their marriage settlement agreement, he has to be given the opportunity first if he wants to take care of the kids. That's what was agreed to in the divorce. That doesn't say no more unsupervised contact with grandma. Now, besides her not knowing about it, what is the evidence? I don't want to mess this up. What is the evidence that supports 2 things? 1, that my client did not know it had been filed, and 2, that Danny Markel was not trying to keep my client from having unsupervised contact with him. Well, the proof is, from Wendy's testimony, that he continued himself because during the course of the marriage and separation and divorce, my client, Mrs. Adelson, didn't just continue to assist, Wendy, when Wendy needed help with the kids, she continued to assist Danny. And in fact, that motion was filed on March the 26th, and the testimony was, for almost 2 weeks in April, my client watched the boys while both parents were out of town. And my client facilitated the Skype with the grandsons for Mr. Markel. Now, if he's really worried about her having unsupervised contact, is he going to leave him with her for almost 2 weeks in April? And he does it again and again. And the last time that he does it is on July the 11th. That's according to Wendy. He comes home and he needs help. She's going to go do something, and then now it's his time to have the children. So he asked my client, Mrs. Adelson, if she could watch the boys, and she does. And she knows he likes this particular kind of banana bread that she makes, and they're going to mock us for this, but that's okay. He likes this particular kind of banana bread. It's got chocolate chips in it and no nuts. And so what did my client do? Before he came to pick up the boys the next morning, the evening before, she makes him a loaf. But she hates him. She hates him and she wants him dead. And clearly he hates her because he filed a motion. It's unbelievable. Us sitting here is actually unbelievable.
And we need the recipe. I'm sorry, you can't just leave it at that. No nuts.
Now, I want to talk about the day that Danny was killed with respect to my client. We're not going to go through all the details again. But what is the evidence about my client? The state has said that my client tried to set up an alibi for her daughter. I don't know how it could have ever been considered an alibi because the man was going to get there at 8 o'clock in the morning, and the evidence is he got killed around 11 o'clock. But State's Exhibit 64 FF is from the Geek Squad. And the state presented earlier that not only did Donna Adelson send an email to Wendy that morning, or before then actually, not only did Donna send an email to her about the appointment, but Harvey, the dad, did as well. And here is the form that was completed, not by Donna, they say Donna arranged it. Mr. Harvey actually made this appointment for the broken television. They had purchased a plan for protection on this television and believe they may get a replacement or a repair. When they made it, you have to fill out some information on the form. And what does this say? Would you be willing to accept a sooner appointment if one became available? Yes. Well, now, are you going to accept an earlier appointment if it becomes available, if you've got a homicide planned? That doesn't make any sense. This is supposed to be her alibi, but they're agreeing you could come earlier if you want. And then the mother sends an email. Do we have that? And what she tells her daughter is, if you can't keep Friday, July the 18th between 8 a.m. and noon, call that number to reschedule. The contract is under Harvey Adelson's name with Dad's cell phone number, but the purchaser is actually Miss Donna's name and cell phone number, and she provides her with a work order. Here, we did this for you, like we do everything else for you, and apparently that's a bad thing according to the state, helping your kids this much. But here, we helped you out, but if this doesn't work out for you, change it. A fake alibi, that's what they want you to believe. You got to read bad into every single thing they present to you to come to the conclusion that they come to. Now let's talk about Defense Exhibit 71. There was, according to the testimony that you heard from the state, Wendy Adelson was interviewed at TPD the day that Danny was killed. They went and found her at a restaurant, and they've introduced these pictures about what she did that day and where she went and how she took the long way around. But she's sitting at TPD being interviewed, and she has requested to be able to call her mother. And unlike other exhibits where the state hired someone to enhance it so you could hear the call better, they didn't do that in this case. And the recording is actually inside the room. You can see it. That's an interview room at TPD. And not only are you hearing what Wendy is saying, there's the victim advocate that testified that my client was shocked when she heard the news. But my client is actually on the other end of the phone, so it's not real easy to hear. But if you put the headphones on, you're actually going to hear some things, and you can hear what my client's reaction is to finding out that Danny Markel has been shot. shot, excuse me. Can we play that? If you could just please put your headphones on. It's not easy to hear.
Do we know how to play that? Watch it be like volume turned up to 11 and all the jurors throw their headphones in disgust. Tell me if you think this call was fake. Like faked as in like, hey Mom, here I am calling from the interview room to tell you that Dan Markel died.
Want to hear?
I need you to sit down. I'm fine, and the boys are fine. Danny has been. You can put me on speaker. Yeah. Danny has been shot. And I don't think he's gonna make it. And so I know. So I found this out around 1 or 2 today, and I'm at the police station, and I'm trying to help them figure out who may have done this.
She found out 1 or 2?
The boys are fine.
6 hours later, she calls her mom?
And they're with Lynn and Ellen right now. And I'm gonna leave here soon and go be with them. But I really need you to come here and be with me. But I want you to either fly, and obviously you can't leave right now, but I need you to get yourself together. If it's too much to drive, I'd really rather that you flew up. I'm at the police station, and I'm gonna leave soon and be with the boys before they go to bed. They're with Alan and Lynn, and they're totally fine. Yeah, the boys are fine, but they don't know anything yet. In his house, I know. So I just need you to calm down before you get in the car, okay? Okay, so, and it's evening, so if you want to come here tomorrow, I have a lot of people that'll, be here with me, and, we'll have a lot of support. So I want you to take your time and just be safe in getting here, but I'd like you to come when you can, okay? Okay, all right. I love you. I think Jane might, I have the car here, but Jane might take me. I'm not going to be alone, so I have a lot of support, and I'll be fine. Yeah, if you could just come here, that would be great. He's in the ICU in the hospital. Okay, but be careful, okay? Okay. Okay. Okay, love you too. Bye. Mom.
I haven't actually put the headphones on, but hopefully that assisted you in hearing. But like the victim advocate for TPD testified, she was shocked. She's not sitting home waiting for a phone call. Let us know that it's done. It's 7 o'clock at night.
She stopped the tape.
And Wendy's calling from TPD.
She took it well, so
to tell her mother that
she sounded
that Danny has been shot.
So that's good.
She has to tell her to calm down before she gets on the road, and you can clearly hear her elevated voice. She's asking about Danny. How did it happen? Where was it at? Well, where's he at now? He's at the hospital. This is not somebody who's planned for him to be killed. Now, the state has made a pretty big deal about the road trip that this 70-year-old man and 64-year-old woman take that evening when they leave their home. It's 11 years
she got stuck
into this case. It's this July that just passed before the investigator in this case, who's given testimony again and again, after he's deposed, decides, I'll go ride the route. 11 years. They've been claiming now, my client, arrested almost 2 years ago, that this ride is completely off, but they haven't even tried it themselves, right? And even when he testified, and also when Agent Sanford testified, first of all, he didn't do the whole route, he did a segment, because he's determined that in this segment is where Mrs. Adelson was at for too long. Did you take any snacks when you did the ride? And he's only doing part of it. Well, yeah. Did you get some coffee? Yeah. But they've calculated this drive for these folks who have just received horrible news and they're clearly upset about it, that they had to be at their son's house dropping off money that was washed, because there's a period of time that it takes them longer to get to their hotel in Orlando than it should have. They took into consideration nothing with respect to their age, that they hadn't had anything to eat. They didn't calculate any time in to stop and get gas, or to use the restroom, or to maybe sit down and have a meal. None of that's counted in. It's got to be a strict from here to there, and you're not there, then you must be doing something bad, and it must have something to do with murder. They give no consideration to that whatsoever. But what's stronger than that is their own testimony from their expert. They have all of these slides that they've shown you where they can show where everybody is in the entire world. And did you notice that for the killers, they had collected records with SunPass and cell towers, etc., and they have a whole map that they're showing you where they went and what they got. They got the SunPass records for the killers. Agent Sanford said that my client was a person of interest from the beginning, but he had her locked in a year. And yet here we are 11 years later, and they never bothered to get her SunPass records. They can get them, they got the killers. If they want to tell you that they're stuck in a certain area and they've gotten off in a certain place, all they had to do was get those records. But they didn't do it. They can prove where the killers are, but not my client. But one thing for certain that they did say is they cannot put my client's phone at Charlie's house during this time period that they say that they took too long to get somewhere. They also testified that there is never a point in time that evening where Charlie's cell phone is hitting on a tower and either Harvey or Donna's cell phones are hitting on the same tower. They don't even have them in the same vicinity, much less the house. But they want you to believe that means Mrs. Adelson was there dropping off money. They have no evidence of it. It's just their theory. That's all it is. You can't convict somebody based on theory. You have to have evidence beyond a reasonable doubt. Now, how about this text message that says outside your house? According to them, outside your house means outside your house. I'm not saying that's illogical to jump to that conclusion, but do you have any evidence of it? No, they can't put her there. And according to State's Exhibit 142...
That's because text messages don't come with GPS coordinates, do they?
If Mrs. Adelson was at Charlie's house, what in the world is she doing hanging outside for over 30 minutes before he gets there? She's got the garage door code to get in, but she's outside the house? They introduced this.
Why did she have
She
Charlie's
had talked
bin?
to him, according to their records. She had been on the phone with Charlie. She talked to Charlie. And then later on, they send this text message, and it could mean many different things. But it would have been 30 minutes while they were waiting there for him to get there. And there's no reason for them to be outside the house because they know he's not there. It took him 10 minutes to send, or 20 minutes to send a message back saying he was 10 minutes away. And then he had to travel there. They don't have proof that she went there. They want you to envision it and imagine it and believe it because that's their narrative. That's what they tell. and I don't think I said it before, but the witnesses, the additional witnesses that testified that Charlie kept his cash, these $100 bills stapled together, that was Miss Umchinda and Mr. Fitzpatrick. They both testified they knew Charlie well, and that's what he did. No evidence at all that my client did that. Do you remember back in jury selection? I didn't do it for Miss Adelson, my co-counsel did, Mr. Zellman. But he asked you a series of some similar questions, and he asked you, would you agree that the state could make a mistake in the theory of their case? Yeah. Would you agree that law enforcement could make a mistake in their investigation and determining who they think committed a crime? Yeah. That was the overall response that we got. It was asked of everybody who came up that got individual questions. I mean, questions as a group. Well, according to Special Agent Pat Sanford with the FBI, do you remember his testimony? According to him, he has never made a mistake. Not one time in his career has he ever thought somebody committed a crime and he ended up being wrong. You know what the problem is? When he thought she was a person of interest from the beginning, and then he, according to his testimony, locked in on Donna Adelson, the path didn't lead to Donna Adelson. They tried to build a path with something as flimsy as these emails that they say are the motive for her to have him killed. They made some other mistakes. Rob Adelson, calling him to testify was a mistake because they've clearly relied on his evidence, and he testified himself. He wouldn't have the basis to give it. He's never around. And then they called Patricia Bird. That's their next mistake. She claims, different ways, that Donna was going to buy her some land and a trailer to put on it, a small car to drive, and fix her teeth to testify untruthfully. She said that a white female investigator actually offered her all of those things. But then when it was pointed out to her that the investigator that came to see her was actually an African-American female, oh, it was her that did it. Then she wants to tell you that my client confessed to her. I asked her, did she do what they said you did? And Miss Donna said yes. Well, she's not clear on this confession because when Mr. Zellman was asking her questions, she couldn't remember if it was Donna said she wrote the checks or she confessed to the whole crime. But here's a woman sitting in front of you that has come up all of a sudden at the end of the game, and here she is claiming that an investigator offered her these things, and that was for false testimony, that Miss Adelson was trying to elicit false testimony, have her come in here and swear under oath and testify to things that were not true. Well, both investigators came in here and said that never happened. She was never offered anything. She never told us that Donna had offered her anything. Most importantly, she never told us that Donna confessed. None of that. She's facing going to prison, and she has an opportunity to come in here and testify against Miss Adelson so she can get a deal. What was she facing, 5 or 6 years? Here's the biggest part. Did you hear what the judge read to you this morning before he started with the jury instructions? He read to you a stipulation. As he explained, that means the state and the defense agree to certain facts, and you must accept them as true. And what was the stipulation? Patricia Bird was never on the witness list for Donna Adelson. Well, isn't that interesting? She was going to come in and testify falsely for Donna Adelson, and she's never been on a witness list.
But defense insinuated she was.
And then you got Drina Bird. This is not just someone who is hoping for some help in her case. She already got it. Her testimony was she is a 27-time convicted felon and or crimes involving dishonesty, facing 15 years in the Department of Corrections as a prison releasee reoffender which means you get day for day with no gain time. Here she comes saying she's got all this evidence, and Donna's offering to do the same things for her that, oddly enough, Patricia Byrd in the same cell block has said is going to happen. What does she do? We tried really hard not to bore you by playing the whole tape, but there's an exhibit that we put in, and it's the video of where Donna and Miss Bernhardt are sitting at a table. Oddly enough, Miss Byrd wasn't there, and she told you that she was with Donna Adelson day and night talking about her case. She wasn't anywhere around when they're sitting at this table, but you can watch that video again. I would just like you to recall this. Who shows up to that table first? Drina Bernhardt does. Who shows up with paper and a writing instrument? Drina Bernhardt does. And while they're sitting at the table, is Donna sitting there just telling her? No, they're having a conversation. How does the writing start? Miss Bernhardt gets out her little hot pink folder, paper, whatever it's called, notebook, plops it open, shoves it towards Donna Adelson, and starts tapping on it. Let's get busy writing. You don't hear those words, but that's what she's doing. Here, write. And allegedly, she's going to do the same thing, give false testimony, and her name is not on a witness list. A little bit more about Catherine McBanawa. No, actually, I covered that. So if this is all they've got, up until the time that he died, just that she said bad things about him and helped her daughter with her divorce, what is the evidence that they have after Danny Markel was killed? They put this evidence in. They got nothing to show that my client was involved in any way leading up to the time that he was killed. But they elicited the testimony that it was 2 months after the murder when Charlie Adelson discloses for the first time to his mother what he knows about the case. Now, all she knows is what he's telling her, but it's 2 months after the murder when he's telling her, well, what happened was I got a girlfriend, and I had told her about this $1 million offer, and she said it in front of some of her friends, and they've gone up there and killed Danny Markel, and now they're demanding money, and so they said if I didn't turn over my third of the $1 million, this is what he claims that they elicited, if I didn't turn over that money, then I'd be dead in 48 hours or they'd kill my family. So he goes into his safe and pulls out $138,000 cash, puts it in a bag, gives it to Katie, tells his mother 2 months after the homicide, now he's being extorted. She works at Adelson Institute. They want you to believe this is a family business. Does family work there? Clearly. But who owns the business? Who does the money belong to? Who is Mrs. Adelson writing and paying all the bills for? Who's she doing the salary for? Everybody there. Everybody there. So he tells her, write around $1,000 a month to Katie McBanawa. It'll save my life. They had this forensic investigator, and they didn't present anything to you, not a single check ever, that Charlie Adelson signed for his business, because he had his mother paying the bills, doing salary and other things at the dental office. That's him paying these people. She's doing her job because he says it'll save his life. She believed it was the truth, so she did what he told her to do. Was there pushback or not? We don't know. They didn't present any evidence about that. They claim she would have pushed back. Maybe she did. We don't know. But what we do know is it's 2 months after the murder before she knows what has gone down. That's their evidence. But she conspired with people to have him killed. She got the hitman to have him killed, and she wanted him killed, and he ended up dead. She doesn't even know about this going on. And the only version she knows is what her son has told her. Did she say, oh, the truth's coming out, the truth's coming out, the truth's coming out? She did, because that's what Charlie had told her the truth was. And that's her son. And she believed him. And she didn't want her son to die. She wrote paychecks at Charlie's instruction. That's not her giving cash and paying off murderers. That's a paycheck to Katie. That's it. That's all she did. So we're bumping along, and now we're in 2016, and it's a bump. Law enforcement testified to you that they created this scenario where they could try and get information to further investigate this homicide. So they've locked in on Mrs. Adelson, so they're going to set her up. Funny thing is, Mr. Sanford testified to what probable cause is that you have to get a wiretap on somebody's phone, and you have to have proof that a crime has been committed, and this is likely the person who committed the crime. It's not proof beyond a reasonable doubt. It's the same that you have to get a warrant to arrest someone. But when they do this bump in April of 2016 to June, who do they get wiretaps on? Charlie Adelson and Catherine Magbanawa. Not Donna Adelson. But they're just sure she's the mastermind behind this. So what do? They follow her. They watch her daily routine. They pick a location where she is taking her grandchildren, Mr. Markel's children, to and from school. And they decide that's where they're going to do this bump. This is State's Exhibit 113 of the bump on the street that took place on April the 19th of 2016. Am I in anybody's way?
Black shorts. What is it? Okay, bud.
Excuse me, Mrs. Adelson? How you doing? Just want to give you this. Listen, no, don't be scared. Listen, just want to let you know that we know that your family has been taking care of Katie and her friend Rebuttal for quite some time after your problem up north has been resolved. And I want to let you know that my brother, he's incarcerated. He helped your family with this problem you guys had up north. And we want to make sure that he's going through some rough times. And we want to make sure that you take care of what he's going through, the way you're taking care of Katie and Tuba. Well, this will explain it. Thank you.
That was the first day on the job for the bump guy, I guess. Very mild bump.
What did she say? You scared me. And he goes on his little explanation, and her response is, I don't know what you're talking about. Now, the state says, from what happens next, which is a phone call that Mrs. Adelson makes, she has to be involved in this murder. Because she doesn't call the cops, she calls Charlie. Well, why'd she call Charlie? because Charlie has confessed to her his role in paying the killers back in September of 2014, that it's his money, claiming he's being extorted, claiming his life is at risk. That's who she's going to call, because guess what? Now this man is talking about the people who are involved in the murder. You're taking care of Katie. So yes, she calls. And the state wants you to believe that there's this huge made-up code. They allowed you to look at the transcripts when that was going on, and you looked, I watched, you were all intent looking at the transcripts and listening to the calls. If you go back and want to hear them again, you're welcome to do that. She's responding to his questions and his instructions not to talk about this on the phone, but he keeps pushing and pushing and pushing, so she's trying to give him a hint without actually saying on the phone what's going on. These are hints, not code words like the state wants you to believe. Can I have just 1 second, please?
You guys have asked for some music? Some very quiet music. Sidebar.
I was told counsel wanted to see me at sidebar.
It's only appropriate to play the music at certain times. So I recognize what you guys are trying to do, but it has to fit. The judge is shaking his head a little bit. A little back and forth. I don't think he likes what's being offered. Did it need a moment?
Members of the jury will take a brief break at this time. If you need to use the restroom, please do so during the break, and we will continue with the closing argument.
Hour and 15 minutes. I need to stop the timer. Sorry. About an hour and
everyone can be seated.
13 minutes in.
If you need to use the restroom or stretch your legs, this is your opportunity. Or something to keep yourself from passing out. This is your opportunity now. 5 minutes.
All right, we get a 5-minute song, so I guess I can recap just briefly what we've got for defense. It starts like this. Jackie Fulford, the defense attorney, if you remember, when she gave her open, the first thing she did was shock all our senses by grabbing the podium and driving it to the middle of the courtroom, over cords, cables, maybe somebody's toes. This time it was different. This time the setup was already arranged. And she took the podium and proceeded to bash it with all her strength for the first maybe the 40 minutes of the presentation. It was as if this was something personal to her, that what the state had done was not an attack on her client, but an attack on her very own credibility, even her existence. And it needed to be rectified. Only after she had set the record straight on all those facts that the prosecution had clearly got wrong did she begin with the closing, the defense of Donna Adelson. But where did she begin? It wasn't at the beginning. She began in the middle, and then she jumped and went to the end, and then back to the middle again. and then to the beginning. And the timeline that she's following is more of a snapshot into her brain of somebody who might need help focusing, because it was everywhere. And yet at the same time, nowhere. I realize that Jackie has a tough job ahead of her. The facts are not on her side. The law isn't even on her side. And all she has left is to bang the podium and yell as loud as she can to get the jurors' attention, to try to cast some sort of doubt into these few facts. As if her speaking it will somehow make it true that Donna had no role in the murder of Dan Markel. Thank you. Thank you. All right, free the podium. All right, I'm sorry. After doing that, I realized that's a little bit of fun. We poked a little fun. We do that from time to time. I don't think she's doing as badly as I make it sound. She is the few points, because this is a circumstantial case, right? The few points that are circumstantial, that we don't know for sure, it could be, it likely is. If every one of those, if she can present another reasonable explanation, I wouldn't say more reasonable, but a reasonable explanation for each one of those, that is her job, and she's doing it. And she's definitely keeping the jury's attention. No, there's nobody sleeping on her on this. This is keeping everything going. The jumping around part, I think it's probably strategic, because this way you don't have to address everything in order, right? We can play Wendy's tape of her making the phone call to Donna in the jailhouse and cut it off right before Wendy says, well, she sounded surprised, so that's good. We can cut it off before that and not address it, because we can then jump to something else. We don't have to hit this chronologically like the state did, from the beginning to end, from the first gibbers all the way down to Vietnam. This is Donna calling. You got room for two. But let's see. We've got somebody on the phone here. Let's see if we can.
Call from. To accept, press 1. To send a voicemail, press 2.
Trying. Not working. All right. It's all right. Is it working now? Hello? Nothing. Okay. The phone is not working well. It's been having some trouble here. All right. Let's go through a couple of messages. I missed a few here, so let's do that first. All right. Quite a few. Kim, I had to turn the volume way down. She was loud, but we heard clearly. Stacy says, in my opinion, she's doing a great job with what she has to work with. She has to come in hot. She does. Mike says, bang the podium counter. We don't have enough fingers to count the buttons or the number of hits. Laura Fry, welcome to the gallery. Thank you, Laura. Appreciate your support. Kim comes in with a super chat. And another Kim comes with banging the music softly, plays music softly, plays in the background. Piano music. The one we just played. Thank you, Kim. We got the music. Kelly H. says, next time, see you. Carrot Bringer member for 12 months. You hit the year marks. Already here. I thought my zucchini banana bread with chocolate chips was good. I thought it was good. Did you hear Donna say that I already know about Dan? Kim, I didn't hear that. It's hard to tell. I think we could put a lot of words in that might match what we hear, but the audio is just not good enough to tell what she actually said. Meddling mother-in-law. love the username. Best emotionally supportive recap. Thank you. And Kim, once again, with the big clap. Thank you very much. Appreciate that. It's a slow clap. Golf clap is what that is, I think. Yay. All right. Hang on. Let's see. We've only got a couple minutes left.
Call from Angela.
This time it's working. This time it's not working. Angela, I'm sorry. I think the phone's not working. I try and it hangs up, and I try and it hangs up and doesn't connect. So we'll try phones maybe later in the day. I'll restart the app in a minute. Ricky C. gifted 5 memberships. Congratulations to those recipients. That was great. I was here for that there. Not only do they think the lady on the porch might butt based on ballistics, 2 different... Hey, well, sorry, I'm just butted into your conversation. Clearly, I don't belong. I'll get out. I apologize. J.D. DeWolf says, R.A. was beautiful. I need a tissue. I can sum it up, says Cass. It was brutal. It is brutal. I think, I'll tell you this. It is, defense is doing a good enough job that I believe the state will need to ask for more time. That is a good sign for the defense. I think that they need to ask for more time. The phone is not working. I'm not going to answer right now. It just wastes all the time when it just doesn't connect. I've got a problem with the app. I just need to restart it. Trying to restart it here now, but it won't restart while the calls come in. Honey's mom member for 26 months. OG. Says, love this family here. Thank you, Honey's mom. Appreciate it. R.A., you're the best. Between serious and entertainment mix, just right. I've got to say, I've got to give this to defense. They have a difficult job ahead of them. Yes, it is a circumstantial case, which usually does help the defense. There isn't a lot of hard evidence, but there is some, and there's a lot of circumstantial, and it all meshes so well together. So very well. And, I mean, how do you explain TV's about 5? I mean, literally, her lawyer in one breath said, here's Donna on the phone talking to her son, trying to follow her son's instructions to not say anything on the phone, but at the same time trying to give him a hint. Say anything about what? About he's being extorted? Seriously? That's what you want us to believe? It seems every single point that the defense is bringing up, the logical leap that is required, the gymnastics required to get to that point, in and of itself is phenomenal. It's Olympic worthy performance to get to it, and then to have to make that leap with each one of the points, it's beyond reason for me.
Angela.
Angela, are you working? Are you there this time?
Yes, I'm here. So, can you hear me?
Yeah, you got to be quick though, because Judge is coming back.
Yeah. Oh, is he? Oh,
he's not back
then
yet.
I'll come back
yet,
later.
But we just have to make it quick.
I just have one question. Why does lawyers have hate doing homework? Because if they Googled, and it takes just a few seconds to Google this, how successful FBI is when doing bumps and arresting criminals soon after that, they're very successful.
Yeah.
The most famous case that I know is a international spy that was caught using
a bump.
Bump.
Mm-hmm.
Yeah.
Bumps work really well because you've got people that are on edge watching their back, and you kick them and basically say all your worst fears are coming true. Okay? That's what a bump does. It shakes them up and says, it's happening. This is it. What's your plan B? And people start reacting, and it's like we can prove everything because of that. And
defense here is acting like the bump is like the worst thing that, at least to me, like the worst thing they could have ever done.
Yeah,
I mean, seriously?
The FBI is bad. They followed a grandma with her children to a school. Yeah, and then what did the guy do? Excuse me, ma'am, if you've got a second, I'd like to talk to you just for a brief moment. Oh, I'm sorry, I didn't mean to alarm you. Hey, that was the bump. Okay. This is no guy shows up with a baseball bat wrapped in barbed wire saying, look, we're going to settle this out back. That would be a more aggressive bump. But the polite bumper, I mean, I think probably in the FBI, that guy is getting laughed at by his fellow employees for how polite he was during that bump. They're like, oh, my, you blew it. You totally blew it. They're going to know it's us. You said please and thank you.
Maybe he wants to be like that, to not, be scary.
Yeah, there's a time for a good cop and a time for a bad cop. He was in the bad cop
Yeah,
mode,
and
but he was still in good cop face.
yeah.
That was funny.
And speaking of I follow this guy on Instagram, which I don't know his handle, but I'm pretty sure somewhere in his handle is FBI agent, or somewhere on his profile does it say that.
Mm-hmm.
But he's a former FBI agent, retired. He has been an agent for more than 20 years. That's for sure. And he tells his stories from his FBI days, what he can say, of course, not disclosing classified stuff.
Right.
And also commenting on ongoing cases that some people are aware of, some are not. And he talked about the undercover stuff and how the process of becoming undercover FBI agent. And no, not everybody goes to that school. It's a special school that you go to, and the whole process of becoming an FBI agent. Not everybody graduates from that school, and it is okay to wash out. No, but he says he knows people that washed out of that school, and
it's
nobody
hard.
will nobody will think less of you if you wash out or decide to not be an undercover, in the middle of the schooling. And he says it's a ringer, because I think he went to that school, if I remember correctly, so he knows everything. So he said it's a brutal school to go through, and if you graduate from that school, you can you only people who can really survive graduate from that school, because you need to be able to survive the worst of the worst as an undercover FBI agent.
Yeah.
So this is like a walk in the park for him. If he graduates from that school,
job ever.
it's like, he probably the easiest money he earned as an FBI agent.
That's funny. Angela, thank you very much. We're gonna wrap up. I think the judge is gonna be back here in just a minute, hopefully, and we're gonna get going. Good talking to you. Thank you very much.
Good talking to you. Bye.
All right. Happy Feet says, all right, why do you not have advertisements? It's lovely. Because I hate watching court with advertisements, and I think you do as well. So I don't allow YouTube to put advertisements in. At least I do everything I can to not allow YouTube to put advertisements in while we're live. There are advertisements on the replay. Obviously, I couldn't do this for free. The advertisements do help pay for the channel and make it all possible. So there are on replay. But I want to watch the way I think you want to watch.
The timer back in the correct position.
What timer was it? I've got 45 minutes. Wow, Knoxville, Tennessee. Storm, power out, tornado type stuff. Stay safe out there, guys. YouTube Premium is worth it. I would, if it's a choice between being a member and buying YouTube Premium, I would. It's worse for me financially, but I'd recommend that you get YouTube Premium, because the watching court is so much better without ads. And if you don't have YouTube Premium, there are still ads that come through. So if there's a choice, but don't pay for it on your iPhone. Oh my goodness, use a computer. It's cheaper. Anything through iOS charges you extra, like 30%. Yeah, I can't get rid of all the ads. If I want any monetization, YouTube gets to put ads as much as they want on the replays. But on every single live stream, I turn the ads automator off, and I ignore every time there's a little pop-up that says, now is a great time to insert an ad. I just don't do it. And I think it works out for the better that way. ads make me feel seen. Knuckles of justice have been cracked. Jury must be arriving here soon. What? I've got to worry about it? Whimsical chaos? I have not checked the weather at all. I think my kids are outside playing. Hang on a second. I wonder if she's going to switch styles at this point. She needs to ramp back up. She can't just start with that level of engagement that she had prior to this. Oh wow! Oh. I'm not in Nashville, so I'm good. I see. We've got lines of thunderstorms and going through. I'm far enough east. I should be good here in North Carolina. Let's see until. Let's see what time it's going to be. Maybe midnight we might get something. Just depends how quick it dissipates. I'm alright. I'm good. Thanks for the heads up, though. Is the fence done? No, they've got 45 to 50 minutes left. Jackie Fulford, the defense lawyer who's giving the closing, was giving the presentation and then paused and asked to approach, and then we got a break. And we don't really know why. It wasn't an objection by the state that I could see. So possibly they were checking to see if it was okay to do something, if the judge would let them use some evidence. They're clearly still flipping through things to see what they need to address. Maybe shuffling and reworking their strategy even in this last moment halfway through the closing. Knuckles get popped again. Waiting for the knock on the door. Yeah, you can claim it. You can file the motion, but it doesn't mean that a appellate court would grant it. There's the knock.
You're entering the courtroom.
Here we go. Pentoufle says, bought the winning Powerball. Will share by Super Chats. Pentoufle, thank you very much. I can't wait to help you spend all that money. I will do it for the team. You know, it's not, my heart's not in it, but if you insist. Thank you for your generosity in advance.
Everyone can be seated. Ms. Fulford, you may continue with the defense closing argument.
See how she continues here.
As you recall from the testimony, there was a meeting between Charlie Adelson and Catherine Magbanawa after the mother had it was after the bump, right? Do you have that? There's a transcript of that. You can't make out everything they say, but this is part of the transcript that I wanted to point out to you. This is Charlie Adelson talking. Don't waste your time with mom. They need to talk to someone who's first person. Wouldn't it make sense that they make a connection to my family, to me, to my family, not my mom? And then he says to Katie, "You're the office help. Checks are on me. That's just because they found out you come in and work on the weekends. Trust me, I'll keep you on full time, so you're going to get your checks." That's Charlie Adelson agreeing that he's keeping her on payroll, and the checks from him will keep coming. After the bump on the street, Mrs. Adelson receives a letter . And the statement from, or the evidence that came from the state's witness, you recall that he said that his instructions on when he met her on the street was to be polite. This is not so polite. The next thing, she gets a letter and it says, so my phone is not ringing, so you don't care about Tato and what he did for you. He knows he is fucked, and soon so will you. Now, it doesn't say I'm going to kill you, but now the threatening behavior is coming, and they're taking the next step to try and get Mrs. Adelson to come out and admit to something. If she pays the $5,000, bingo, right? She doesn't do that. So that happened on April the 26th. Then she does nothing still. She's scared, and you recall from the phone calls, she's scared. She thinks it's someone related to the killer. She's worried about her safety. She thinks something bad is going to happen to her, but Charlie just keeps saying, Mom, everything's okay. You have nothing to worry about. Then on May the 4th at 2:09 in the morning, the undercover sends her a text message, 2:09 in the morning. So you don't take me serious. You think I'm playing. You have some puta call me to see if I'm for real? If you think what Katie baby daddy did for you can't come back, you're fucking crazy. I want the now, or I'm going after the 100K. So, threatening. I'm going to go to the police. This is not going away. Don't think that I'm gone. We're still here, and you're going to do something about it. That happens on May the 4th. As you recall from going through the wire summary with the state, other calls take place in between. And then on May the 6th, finally, Donna calls the undercover at the number that he had provided initially, that shows here on State's Exhibit 83 with the article about Danny Markel being murdered. Call or text, that's the number that was provided, 305-712-6570, and the dollar amount of $5,000. Now, the state has said to you, innocent people don't fold the paper up and put it in their pocket. I'm pretty sure there's not going to be a jury instruction that tells you she must be guilty because she folded it up and put it in her pocket. She took it very seriously. She got her grandchildren, she went home, and she immediately called Charlie to report that. But now she's calling the number that was provided, and you've heard from the testimony, she downloaded an app so it could be recorded, but of course it was being recorded by the undercover as well. Could we play that call? And I think we have provided a transcript to you because it wasn't provided previously, if you'd like to read along.
This is Mrs. Adelson. Is this Sammy? Sammy. Okay. My grandchildren had my phone before, so
And you're Adelson?
I'm Mrs. Adelson.
Yes.
My grandchildren had my phone before, so that's, and I just saw that you called.
Oh, okay. You left a message on my voicemail.
Right, you did.
No.
This is my problem. You approached me on Alton Road. You handed me an article from the newspaper about my ex-son-in-law. You told me I need to call you and help your friend who is in prison. Now, at the time you did that, I didn't understand what you were talking about. I didn't call you back. Then you mailed me a threatening letter. Then you send me a text message to my phone that says I'm not taking you seriously. So I am taking you seriously. And I really want you to listen to me. I have to tell you, I mean, this is important. I have been so stressed out. I have spoken to 10 or 12 people who are close friends of mine, telling them about this and basically picking their brains and asking them what I should do, because I don't know your friend who is in jail. You mentioned a name. I don't even know his name. I never spoke to him. I don't know what he looks like. I've never met him. I'm sorry your friend's in jail, but I don't know what that has to do with me.
You know exactly what it has to do with. You know exactly what. Listen to me carefully. Listen to me. You just got to listen to me.
You need to ask who this person looks like, or what their name is, something, because I know there's a big reward out there, and if you need money for your friends, that's the way to get it. I mean, I'm asking you nicely. I don't know who he is. I am out of the loop. It is not me. If I can help, I would help. I mean, that's what.
Just like I told you, listen to me. Just like I told you that day, we know that your family had a problem up north. We know that problem was taken care of about 1.5 years, 2 years ago. And we know that Katie has been taken care of. And has been taken care of. Now my brother in jail, we were in Broward together. He told me the whole thing. And he hasn't been taken care of. You know. Now, all that's being asked for is 5K. That's all we're asking for is 5K. And he told me everything, and I know everything. I know who's involved. I know everything, and I'll get the 100K for myself.
You know,
all I ask is to send the 5K. Everybody knows what's going on.
I don't, you're saying everyone knows. I know I lost my ex-son-in-law. I did not have anything to do with it. That's why I said, ask him what. That's what my brother Tato told me. He told me everything when we were in jail. He told me everything and who was involved. I know everything. Well, I don't. That's the problem. I'm telling you, it's not me. It's not me. I have had a year of aggravation, 1.5 years of aggravation over this. My daughter, my grandchildren. It is not me. And when I asked my friends, what do they think? They said, well, this person needs to get a description of you because of what you look like, or it's not me. I don't know who caused this. It wasn't me. I mean, I don't know.
I'll tell you, just like that day when I talked to you, this is not going away. This is not going to go away. The Tato told me everything. He wasn't being taken care of. He needed the 5K. Spend 5K. That's all we were asking for. Don't do that.
I don't know who Tato is. You don't understand.
We know you know who Tato is, but you know who Katie is. And you know the contacts Katie has, and she has, listen to me, let's stop fucking around. Let's stop fucking around. Okay? You know who Katie is. And you know that Katie has somebody that knows stuff. And they took care of a problem for you people. That's just the bottom line. The bottom line is you know who the fuck Katie is.
Look, I don't.
I'm not fucking around with it. You know who Katie is. You know that they took care of Katie and her people. Nobody's taking care of Tato. I know you don't know who Tato is.
No,
but we know who all of you are. And this ain't going away.
You know what?
So I can give you that. You want to send the 5K?
Here's what you need to do. You need to go and...
Don't tell me what to do. I know what to do and I'm doing it.
You're looking for money. Get $100,000 or whatever whatever the reward is. It isn't me. You have got the wrong person. That's why I said ask your friends.
You're Donna Adelson.
Yes, I am. Yes, I am.
Well, I know. We know who's involved in all this.
Yes, this is not making any sense. I mean, if you want the money, you should get it from the police. They can give you a whole lot more than you're asking me for money for someone. I can't do this. I have had too much stress and too much aggravation from this, and I don't know what you are talking about. I just don't know. I just don't know.
Good. I think you should talk to Katie. Talk to people that are involved in this. You'll know. You know what's going on.
That's why I'm.
You can tell me. You know that Adelson, you can tell me all you fucking want, but I know you know. Because I know, because I heard, when I was locked up in Broward with my brother Cecil, he told me everything. Everything. He told me everything.
Well, then
I just wanted to take care of him because fucking Katie was being taken care of with her fucking people.
I just think instead of asking me, you should get the money from the police. There's a lot of money out there, and I know if you think you know who this is, then go ahead and do it, because I know it isn't me. I know it isn't me. And I can't take this kind of level of stress. I just can't. I know I didn't do anything.
To talk to people, you talk to the right people, you talk to people, you make this 5K come to me. That's all I need. Just do it and get it to me. Do it and get it to me. Bye.
They tried 5 different times. I'm sorry. Did you want a particular position?
Leave it right there so it's not moving around.
Sorry, Judge.
Please don't move it.
5 times they tried. They tried to get her to pay the money. They tried to get her to admit that she was involved in this, and 5 times it failed because Mrs. Adelson tells them in this call, he keeps telling her, I know everything, I know everybody, I know what happened, and she tells him in this call,
no,
if you know, go to the police.
He says,
go to the police and get the reward. Why in the world, if she's guilty of committing these crimes, is she telling somebody who apparently knows everything to go to the police? If you're guilty, you're not sending anybody to the police. That's why they think they can get her with the 5K. But she didn't do it. And still consistently, Charlie is saying, nothing to worry about. Don't worry. You can hear the fear and worry in her voice on that call. Now, the state talks about coding and code words, and one of the things they say is that in one of the discussions with Charlie, Mrs. Adelson says, it's about the 2 of us. It couldn't be more clear what that means. Her son told her in September of 2014 that he got extorted, he has to pay this money, he has paid the money, and he's going to keep paying the money so he doesn't get killed, right? Now somebody has walked up to her on the street about the exact same subject, Mr. Markel being killed, and demanding $5,000 from her. So now he's brought her into this. It is the 2 of them. They're not knocking on his door. They're coming up to her on the street. They're sending her text messages. They're sending letters. They're calling. They won't stop. But she didn't do anything. If her son did, that's on him, not her. There's no evidence that if Charlie Adelson had not told her in September of 2014 what he told her, there's no evidence that she would know anything at all about what happened. That's her single source. And he brought it to her. Bring cash. That's one of the things she says. Bring cash. Without telling him what has happened on the street, she's telling him they want cash. That's not code. That's hint, hint, hint. You don't want to talk on the phone, but you won't stop asking me, so I'm going to hint to you what this is about. There's nothing code about that.
The
state is interpreting what they think these things mean. It's not their interpretation that matters, it's the evidence that's presented. The judge has read you the jury instructions. So I'm not going over all of them with you, but I want to say this. Murder in the first degree, the state has to prove that on July the 18th of 2014, Donna Adelson intended that Dan Markel be killed on that date. They have to prove that. There's no evidence of it. First-degree murder is killing with premeditation. Is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. They've got no evidence of her doing anything until after Mr. Markel is dead, when she writes the checks at the instruction of her son. Conspiracy. The state has to prove beyond a reasonable doubt that the intent of Donna Adelson was that the offense of first-degree murder would be committed on the date that he's killed, not after the date, before and up to the time that he shot and killed. They have to prove beyond a reasonable doubt that she had that intent, and they have nothing. Solicitation to commit first-degree murder. They have to prove the following two elements beyond a reasonable doubt. I'm sorry, back to conspiracy. I forgot to say this. In order to carry out the intent, Donna Adelson had to agree, conspire, combine, or confederate with Charles Adelson or Catherine McBanawa or other persons to cause the first-degree murder to be committed. Had to be before. No evidence of it. Solicitation. Prove the following two elements beyond a reasonable doubt. Donna Adelson solicited Charles Adelson or Catherine McBanawa or other persons to commit first-degree murder. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. What does solicit mean? It means to ask earnestly or to try to induce another person to engage in specific conduct. We know that the state has not presented evidence of Mrs. Adelson actually shooting and killing Dan Markel. They are asking that you find her to be a principal, that these other people did the killing, but she's a principal. And to prove that she's a principal, you have to show that she helped another person or persons commit the crime. In doing so, the state has to prove beyond a reasonable doubt that the defendant intended the crime to occur and the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Daniel Markel occur. Then you heard the instruction of a principal when active participant is hired by the defendant. If the defendant paid or promised to pay another person or persons to commit a crime, to commit a crime means she paid or promised to pay them before they killed him. There is no evidence of that at all. No, she never paid any of her money. All she did was write the checks that her son told her to write from his business account.
She kept the books. She did payroll.
So you have to show that she made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime. Nothing. There's nothing at all linking her to Catherine McBanawa, Sigfredo Garcia, or Luis Rivera. Her link to Charlie Adelson is it's her son. They like to show those little arrows going back and forth like it's a train, I think they said. This isn't a train. This is somebody's life. Danny Markel's life. And now Donna Adelson's life. This isn't cute. This isn't powdered sugar. They have charged my client with first-degree murder, conspiracy to commit first-degree murder, solicitation of the people to kill, and their example is she's got powdered sugar all over her. No, she doesn't. They want you to believe it. That's their theory, but a theory doesn't prove a crime. They have to present evidence, and they haven't done that. Let's talk about Vietnam. and the evidence that the state has introduced. Their exhibits 129 and 130 are the visas for Donna Adelson and Harvey Adelson. That one's Harvey's. Would you put that one? Now, there's something very important about these. It says their name and what they're going to do. You see that line? It's in, I guess that's Vietnamese, but underneath it, it's in English. And it says, good for single/multiple entries. That it is a visa for tourism, not residence. It's a visa for tourism. They can come and go as they please. And that it is good until, where's that date?
Date of expiry on the right. We're zooming in.
Here it is.
Literally
it's
right
good
in the middle.
until, they put the dates backwards. So this is February the 5th of 1950. And the state says, oh, well, she was going to be gone past the date of the bar mitzvah. This visa allows them to come home, and if they want to go back, go back. Now here's something really important. The state said that we're trying to tell you she was going on vacation. That's not true. Her prior attorney testified that before there was a conviction, she was very upset and said she wanted to kill herself if her son was convicted. And her husband was concerned about her doing that, so he wanted to get her away, to clear her head so that she wouldn't take such a drastic step. That's not a vacation. She's beyond herself. And then he gets convicted. And it's worse. And here's the thing. The state has been saying, since this woman was arrested, that she was going to flee this country to avoid prosecution. Flee. She's going away. She is not coming back. She's going somewhere where we could never get her and bring her back. They took almost nothing with them. They took a few credit cards, some cash, 2 pieces of luggage, and 1 carry-on.
They could buy anything they needed. And everything.
This is Defense Exhibit 147.
Love that Pelican case there in back.
Was executed,
the yellow tape on it.
After Mrs. Adelson was taken into custody, here's the luggage in plain view with the tags on it to go to one stop and then to Vietnam. And that's terrible.
It is.
I'm sorry.
Should
I'm
focus.
criticizing. I think you got to hold it. In any event, there's the luggage. It's there when the search warrant is executed, and the gentleman from Miami, what did he tell you about that when they executed the search warrant? They didn't even look in the luggage to see what they had. Not even look in the luggage. More important than that is they conducted, according to him, a thorough search. And this is State's Exhibit 160. And it's not real easy to see, and I might just have to pass it along to you because this is really blurry. You see that little light down there underneath the white shirt? See that? That's the size of Mrs. Adelson's safe, sitting there on that little shelf.
What?
They never even bothered to open it and look in it to see if there's any stapled cash. That little bitty safe on that shelf, is that where she allegedly got $138,000 in cash and washed it and stapled it after she got this phone call and took it up to Charlie? Never happened, couldn't happen, wasn't going to happen. And the investigator was so concerned about it, he never even touched it.
You guys see a safe?
But here's what the state presented, and just like so much other evidence that they presented in their case, this is a state witness. And on cross-examination, when asked, Sergeant Chris Corbett testified there was no proof that they were actually going to flee. When confronted with the 90-day visa, his testimony was, well, they were going to be gone a long time. That's not fleeing. That's not avoiding prosecution. She got arrested almost 2 years ago under that claim. And it took them almost 2 years to come in here and have a jury seated on these serious charges, and they finally admit there was no evidence that she was going to flee.
I don't think they admitted that. We had the emergency visa, the non-extradition country.
Danny Markel was killed on July the 18th of 2014, and Mrs. Adelson, according to Agent Sanford, was a person of interest, but she was not arrested in 2014. They immediately started, according to him, gathering bank account information, emails, phone records of Donna Adelson. 2015, she was not arrested. In 2016, they conducted the bump operation against Donna Adelson, and we've just gone through that entire bump operation. And still, even though others were arrested, Donna Adelson was not arrested. She was not arrested in 2017. She was not arrested in 2018. She was not arrested in 2019 or 20 or 21 or 22. Not arrested. And what did Agent Sanford tell you? That they had listened in on this call or heard the recorded call where Mrs. Adelson thinks she's gotten cut off from her son, and she's talking about going away, getting airline tickets, and she wants to kill herself. She talks about it on there. She wants her and Harvey to do it together. And he wants to get her out of town and away from the media and clear her head. And Agent Sanford said, here's how invested he is, they think they might get a warrant for her on the day that she's arrested. They're not sure if they're going to try or not. But maybe they're going to. So he's up here in Tallahassee, and what does he do? He hops in his car and he starts driving towards Miami, not even knowing whether they're going to try to get a warrant. When Mrs. Adelson got her visa, there was not a warrant. She was doing nothing wrong. When she booked the ticket, or Rick Sugarin helped book the ticket, there was no warrant. She was not doing anything wrong. She got advice of her legal counsel that there was no warrant. There was no promise with Mrs. Kappelman, but her lawyer told her of the possibility if they got a warrant, she could self-surrender and turn herself in. She packed her bags, no warrant. She gets in her car to drive to the airport, no warrant. She gets to the airport, and sometime therein, they actually get a warrant, and she knows nothing about it.
She's not supposed to.
They go to where she is seated with her husband, waiting for the flight to board, sitting down amongst the crowd, and they watch her and wait, even though they've got a warrant. They don't arrest her. And he gives some, oh, well, you know, there was a crowd of people. There's no more crowd than when you enter the jetway and everybody's trying to get on the airplane. They waited until she presented her ticket and walked through the little door so they could say that she was actually fleeing. It was a setup. They knew exactly what was going on. They set her up so they could claim, oh, we captured the matriarch murderer. She was fleeing the country to flee prosecution, never to return. It was a great story. Got a lot of headlines. Spun with their theory. But we're in trial almost 2 years later, and they know she wasn't fleeing this country. You know, I'm gonna sum it up here. And this is from the state's evidence. TPD, FDLE, the FBI, and one agency in Miami-Dade are all involved. They have people listening to phone calls around the clock, 24 hours a day during this 2-month bump period. In their investigation, in their words, they have collected hundreds of thousands of emails. Over 2,000 phone calls during that 2-month period, recorded text messages, bank records. They got experts analyzing all of this stuff. They got cell tower records, and I don't even understand all that stuff, but it supposedly can place you in places. They've been working on this case, according to Agent Sanford, right up until the time he was sitting on the stand, still investigating Donna Adelson. If you were going to have proof that Donna Adelson committed a crime, you should have had it beyond a reasonable doubt before you put handcuffs on her in the Miami International Airport. They still didn't even know that day if they were going to arrest her. In all the evidence they have collected, she can't help herself but run her mouth. Not a single email, no phone calls that are recorded, no written documents, no emails, not one single thing that said anything about wanting Danny Markel killed. The most aggressive thing they have are her foul words and wanting to aggravate him. This is not, could she possibly have done it? Could she probably have done it? Might she have done it? You have been sitting here hearing testimony for almost 2 weeks, and there's not a single piece of evidence that connects my client to that murder. Charlie Adelson? Yep. Potentially Wendy Adelson? She's the one who said she hated him. She's the one fighting with him in court. Donna Adelson? Nothing. Not a single piece of evidence. You have to find her not guilty because they have failed to do their job on all 3 counts. They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it. Please take this case seriously. Please go back and review the evidence. Please discuss what's been presented. Don't get talked into something that you don't agree with. The verdict has to be unanimous. If you don't reach an agreement, if you can't be unanimous, there's another procedure we go through. But please don't buy into what the state is about to do, telling me how wrong I am or telling you how wrong I am about everything and how they have this mountain of evidence, because they admitted it. Agent Sanford admitted it. There is no direct evidence linking Donna to anything. And all this circumstantial evidence isn't really circumstantial evidence. It's argument about what it could mean, what it possibly mean. Could it have been? That's not beyond a reasonable doubt.
Isn't that circumstantial evidence?
Ms. Fulford, State, you may give your rebuttal.
Okay. Let's close this one down to go back to the State. They have 7 minutes and 6 seconds left. We'll probably get a little extension here. You can leave it, she says. You can leave it. I just don't want you crawling around the floor like a zoo animal, distracting my jury while I'm speaking to them.
Well? Y'all tired of hearing lawyers talk yet? Down for another hour or two? Kidding. I think I've got 7 minutes. He hasn't started the timer yet. Okay. It does not matter what Miss Fulford thinks, if she's right, if she's wrong, if I'm right, if I'm wrong. What the lawyers say is not evidence. You have the evidence before you. They say it means one thing, I say it means something else, only you guys decide, right? I think outside your house means outside your house, but apparently outside your house means something else. I think a very contentious divorce means a very contentious divorce. They think it means an amicable divorce. You guys decide, right? Look at the evidence and you guys decide. Is everything not what it seems and actually something else? You guys decide. A TV repair appointment is not an alibi because she could have changed it to earlier, but she didn't change it to earlier. That's where she was when he was getting killed. That's an alibi. This TV, that doesn't mean, that's not code, that's a hint. A hint for what? It's code. What does it involve? The two of us. Oh, well, that actually means it doesn't involve the two of us because we're being extorted, we're victims, it doesn't involve us. So what does it involve, the two of us, actually means it does not involve the two of us. That's what we've heard. A one-way non-extradition ticket to Vietnam? It's not fleeing. It's a setup. How did I set her up? I didn't make her do that. I didn't get her a fast track visa. I didn't get her a one-way ticket. She did that. She made those choices. Wendy didn't bother to tell her mom she was ready to give up on the relocation. Yes, she did. Look in the emails. She was giving up, and Donna wasn't having it. That's when she gets the totally unhinged email from her mother suggesting, you're not going to give up. You want to move on with a sense of peace? Hell no, we're going to fight this guy. We're going to dress your kids up as Nazis. That's what happened when when Wendy suggested giving up. Never, never, never give up, right? This murder charge is not based on the fact that she said some bad words. I mean, I'd be facing murder just in this courtroom. Obviously, people. That is not what this case is about. You've got to look at all the evidence. I mean, it is death by 1,000 cuts. It is powdered sugar. You've got to look at the whole thing and make a decision. And I'm sorry that there's not a smoking gun, but she was too smart for that. She thought about it. She planned it. She made sure we could never get her.
I'm going to show that picture again.
She took precautions. But she did make mistakes, and that's what all those exhibits are. Mistakes. My spin and the spin I'm putting on all the evidence, that's not, it doesn't matter what my spin is. It's your spin. You look at the evidence, you decide. I tell you what I think it shows. They tell you what they think it shows. Here's the other side. And what do they think it shows? They don't have to prove anything. I have to prove the case. Yes. But what are they saying? Circles. Wendy. Oh no. Charlie, definitely. Wendy, maybe. Not Donna. But also, not Charlie. We were getting extorted. Not Charlie. I mean, you can't have it both ways, right? It's like hard to get your head around it, but we can't be getting extorted by the killers who killed Dan Markel on their own. And also, Charlie's pretty guilty and Wendy looks a little guilty too. It's got it like, there's no lane that's been picked. And they don't have to prove anything, but they're throwing all that out, right? And it's like, you were getting extorted, or Charlie and Wendy did it behind your back and they don't tell mom what they're doing. Can't charge Donna because Charlie already went down for this. No, that's not true. Everyone that's responsible for this murder should be held accountable for their role. Not just Charlie, not just the two killers that came here and shot him. Everyone that played a part in it should be held accountable. They said some things in their closing that doesn't comport with my recollection of the evidence. For example, Corbett said that the defendant did not send the Evite. My recollection is the complete opposite. You guys took notes, you have remembrances, you guys rely on your own memory. I don't want to go through every single thing, but there were a few of those. The only complaint from a 3- and 4-year-old was, Grandma says you're stupid. Oh, that's dumb. Well, no, I remember that the kid also said, Grandma hates you. Rob has an axe to grind. Mary Hull said that the Adelson Institute was Charlie's until 2022. Not my recollection, but hopefully you remember that it changed hands in 2015. No SunPass records. Do you need SunPass records to know that Donna Adelson was outside Charlie's house on the night of the murder? We didn't know that. Catherine Magbanoa told us when I got to Charlie's, he told me his parents had just come, right? And brought the money. But when we looked in the records, there's a text outside your house corroborating what she said. That's important. She was outside his house. Oh, well, she had the garage code. Why didn't she go in? I don't know if she went in. Maybe she did. She told him, I'm outside your house. He said 10 minutes. He's going to be there in 10 minutes. Maybe she did go in. I don't know. But she was there. That I do know. I don't know why she's denying that. Grandma motion. We disagree with what the words say. I mean, I don't know what to tell you. I say the words say, I don't want the kids around grandma because she's disparaging me. Somebody needs to be there to monitor. They say, no, that's not what it means. It means something else. Charlie's extortion story. She wrote the checks because she had to save her son's life. Well, right. So if that's the case, we're picking lane 2 here, down below. And that's where all that evidence comes up about that pushes back on that. Like, that couldn't happen. They're not going to be spitballing the drug dealer defense years after they've been extorted. Like, that didn't happen. That was a lie, right? That Charlie came up with in his testimony, and that she then kind of got stuck with after saying all the truth is out, truth is out, truth is out. Plus, she's got to come up with something for writing those checks. She paid for the murder.
Please approach. You're out of time. She says, can I have more? He says, please approach. Anyway, Stacy, we are in overtime. The time is, I'll pause it right now. She hit 1 minute. She hit, sorry, I have to be careful how I slur my words. She hit the 1 minute mark, and is, I'm sorry, that was not mentioned. That was not supposed to happen. Do what I say, do what you're supposed to do, not what I say. Is that what it is? Do as I do not, anyway. That's enough. I said the word for you. Thank you, Kaylee May. I appreciate it. I think we get a little more time here.
Please continue.
That's it.
Sanford said he never made a mistake. Not my recollection. What's the pushback on extortion? Her behavior on the wire. She doesn't say, oh my gosh, it's happening again. She doesn't say anything about the prior extortion. If the prior extortion had occurred, she would immediately tell him it's happening again, or some reference to the fact that this is something that's been ongoing. She doesn't do that. Instead, she talks in code. It's a TV. What the heck? Why are you talking in code? Her Googling extortion versus blackmail 7 days before Charlie's trial. That wouldn't happen if the extortion was real. She wasn't extorted. Charlie didn't tell her there was an extortion because there never was an extortion. She was paying for a murder. She knew it was going to be a murder. She's the one that wanted it done. Her discussion of Charlie's lawyers meeting with Garcia's lawyers. What? If she was being extorted by Garcia and Charlie was being extorted and his life being threatened by Garcia, their lawyers aren't going to be meeting up. Look at those text messages. She said, bring cash. They say, oh, that's not code. She said, bring cash. She literally said, bring cash for dinner on that call. It's not a hint. It's a code word. They say the bump failed. I say the bump succeeded. She said it involved the two of us. That was before we got made, before that Matt Surrey operation where they literally see the camera in the bag and know the camera's in the bag. Yeah, she called and put on a great show when she called the undercover, but what did she say in the first call, the second call, and the third call before we got made, before she knew it was law enforcement? She said it involves the two of us, both of us. To these, okay, I want to hit one more thing. Don't call time on me. 2 years after the murder, we've got two emails, 64T and 64I. The defense told you in opening that this defendant cares about others more than she cares about herself. The problem is that she decides what other people need, what's necessary for other people in their lives, and she is willing to justify whatever ends she thinks are needed, right? Any means to get to those ends are justified in her mind. The problem is she doesn't care about the collateral damage to get to her ends. The evidence has shown that this defendant, I think, did believe that Wendy and those boys were better off in South Florida. She thought that's what they needed. They would be better off with her, and she was angry that that couldn't happen. Dan Markel was the thing standing in the way. What was the cost of that to not only Dan Markel, but to those little boys? Those little boys lost their father. Look what she says in 64T. Children are 2 and 3. Children do not even have a memory of life before age 5 or 6. Look what she says in 64II when Wendy is concerned. This is 2 years after the murder. Her child is having trouble at school, crying because he misses his father. And this woman, this nice grandmother, innocent woman, says, quote, "I still do not believe that Ben is sad about his father." Quotations on the sad. 64II. "I still do not believe that Ben is sad about his father. I spend a minimum of 25 hours a week with him, and oftentimes more than that, including weekend times and sleepover days, and have never experienced a time when he was sad. I think it's just another phase of the many, many phases that kids go through. The problem is they have a highly intelligent and sensitive mom." She doesn't believe that this kid is sad because she can't take accountability for her own actions and the catastrophic consequences that this had on everyone's life in her family. Not just her son, not just her daughter, not just Rob, not just Dan Markel, but those boys who lost their father. It wasn't better for them to be in South Florida. It was better for them to have their father. You must not base your verdict on the feelings of sympathy, prejudice, bias. Your verdict must be based on the evidence and the law. Yes, she's a grandmother. Most murderers don't look like that. But the evidence has revealed what she is. Please don't let her appearance influence your verdict in any way. It involves the two of us. What about the script? They didn't even talk about the script. She wrote a script for a witness that was perjured testimony based on a lie, an extortion lie that's been proven in court to you to be false. This defendant tried to erase Dan Markel, thinking there would be no harm to those little boys. They don't have a memory of their father. They feel the absence of their father. This defendant decided they didn't need their dad. She doesn't get to decide that. She wanted it done. She brought the money. She stroked the check. She didn't have to do that. Charlie was a signator, had signing power on that account. He could have written the checks. She wrote the checks. Why? Because she was neck deep in this thing. She wrote the checks. She said it involved the two of us. She wrote that script. May you have the strength and the common sense to see this evidence for what it is. It's only one thing. There's only one truth. It can't all be right. It's only one truth. Render a verdict that does justice. Find her guilty. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The photographic, disc, jump drives, reports, and document exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Before the deliberations begin still afternoon, we are going to discharge at this point the alternate jurors. If the clerk could please read out the names of the alternates.
We're going to mute that. There are 2 ladies who are alternate jurors. We're going to have 8 men and 6 women.
Let the bailiffs know. I will have my assistant contact you with that information. We thank you for your service. You are excused at this time. Members of the jury, you may follow Ms. Tolbert and Ms. Vance. Your instructions and your notepads with you at this time. One moment before you go back in. The transcripts of the recorded call, these are to remain out here. Please leave those in your seats.
Make sure you leave those on your seats, please.
Only the jury instructions and your notes.
Okay, we're going to wait for the sound of the door to close to count the timer, even though it might take a minute or 2 for them to get back in the jury room and start deliberations.
I'll send you a bill.
So it just broke something in the courtroom.
Deputy Bunk, if you can check on the radio to see if there's another jury room possibly that they can be taken to temporarily while the headphones and the audio equipment is moved.
Okay, Judge, we learned that the headphones can just be unplugged, and there's stuff already set up back there for them to plug them in, so we don't have to do anything with that.
Well, that makes that perfect then. Everyone can be seated. If the parties can review the items that will go back into the jury room with the jurors. The instructions that were read aloud with a copy of the verdict form. You can inspect that as well before it goes back. I will hand that to the clerk at this point. Instruction 4.2, instruction upon discharge, that will just remain out here as the case is not yet concluded. Also, please leave your phone numbers with the clerk so that way if there is a question or a verdict, everyone can quickly assemble. Unless there are any other matters to address for the court, we will be in recess at this point.
Nothing that I'm aware of. Judge laughs. You should be aware if there's something from your side that needs to be raised.
There's the instructions.
And the verdict form is in here?
Verdict form is in there. Check for pages 8 and 9. For everyone else, you may step outside the courtroom or you may remain at this point. We will be waiting for the jurors.
Judge saying we are now officially in verdict watch. Timer has started, and wow, what was the total count? I missed it a little bit. Total count of laughs, I think we were just around 80, the law and laughs counter, with the couple that came in just there at the end. Sorry, I'm looking at some really cool hardware there. That's audio guys having a good laugh, fun times. Lots of people meeting up, some supportive hugs. Dan's dad leaves. And I think we're about to see that. Yep, there we go. All right. With that done, we're now in verdict watch officially. And Aunt Karen says, and now what? What do we do now? Well, we can do a couple things. We have a, we know that the verdict will not be read suddenly. And by that, I mean, we're not going to just be like, hey, they just knocked on the door. Come on in. Here's the jury. We saw that in the last trial, and that was incredibly quick. The judge said, leave your numbers, your phone numbers with the clerk. Everyone's going to have time. They can leave the courthouse. They're going to have time to get back. It will probably be at least half hour, which means that we can do a little jump. We can watch a little case out of Tumwater, Washington. Well, we've got the verdict watch going, and the timer is going to keep going. As you can see, I've got it down here. We're only 3 minutes in. I'll keep the timer rolling. Let me go back and get. I think I need to grab it from Media Player 2. Hang on one second. To set my network location to that one. Then we go to play. Let's see what the last one is. A minute trying to find the right court case. Bunch from Donna. That's not it. I'll tell you what, let's play it through this way. We have a palate cleanser, something to watch out of Tumwater, Washington, where they just arrested a guy doing like 135 driving through their little town, which they frown on. If you're familiar with Tumwater, they like to enforce some of those traffic laws quite strictly. And I mean, they can't drive over the Gore Point and things like that. 135 is definitely out of the question. So maybe the court case for that will be coming up here soon. Okay, so we have. Oh, cool! I forgot I could do this. Sweet. Black Magic, Big Deal 2, yesterday at 9 p.m. Let's bring this over here. All right, y'all have a good SOV set, right? We have one. Let me bring this up here. I still have audio. The audio is on right now. So right now, if the court in Florida, if this court were to do anything, you would hear it. But right now, we're going to listen to this court as well. So have no fear. Have no fear. We're all good. We've got everything covered. Let's see. We are up in Tumwater, Washington, waiting for the judge. I don't know if I can find the right mouse. There we go. Make sure I got sound.
I would take it. Yeah, just put it in file. But that just doesn't change the court date. It does change. Mr. Blatt, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
District Court. This is the first sign. This is your first warning flag. Red flag goes up right here if I was the judge.
Your Honor, if I may, a couple things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
last name is Kidmacher.
Okay, and first name?
It's Gabby.
Gabby's like,
okay.
Oh, good.
And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And the bond is equal to the insurance that a driver would need to have.
So I do have a oath of office. It's good. The auditor's office. If you want to go there and get it, you can certainly look at it. But like I say, I don't carry it with me. I don't have it on the. I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't. We're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now, at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
Oh, he's
But the city
winning.
of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Of course, yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes. So
I don't agree with your terminology there in terms of what they franchise. If Tumwater is a municipality, they have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this, not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the third degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies obviously would be under the revised code of Washington, and that would go to Superior Court. But this is limited jurisdiction. And we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple. And that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
He says, I hope not.
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. And don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the third degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. And passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving, and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving And were you validly licensed or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of
So
that.
hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different.
Yeah, good luck.
Now, I noticed something on the website for the court. It says jury instructions or jury guide.
So hang on just a minute.
He goes right
before we get there,
next.
can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And we can have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county, and it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
yeah,
right?
Typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judges to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
It's a different
and I'm going to bring up to the jury the issues of law. My question to the court is how would
here in a second, I'm going to stop you for a second. You're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree. And the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some
spoiler alert.
The right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court, and that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave, because it's at 2:30. And we have some other people coming on at 2:30. We're going to take care of those cases, and then I'll come back and speak with you some more. All right?
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts, and basically juries have been neutered since the rules of evidence have been implemented in 1936. I don't want to serve anymore,
if that's what happens.
But this jury is going to hear the law as well as the facts, and I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Well,
that's a good question. I guess you'll find out if you take this to trial. But we're going to stop for a minute. I'm going to take. There's a couple people who are. We're going to take these cases, and then we'll come back to you. But don't leave.
Don't leave. You can't go.
Mr. Merrill, do you want?
Now we're going to fast forward. And Leonard Blatt gets to hang out and just chill for a while, and then we're going to come back to Mr. Leonard Blatt right here.
Very much, Your Honor. I'll see you guys soon. Thank you, Madam Prosecutor. Thank the court staff, Your Honor.
Thank you. Your Honor, if I may just flag on that other case, the docket does not reflect the pro se call we have.
Okay, yeah, we'll talk about that. Thank you. Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Yes.
Okay. Okay. Well, again, that's what everybody wants. So do I. But
here we are.
But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. You were making a distinction between jury trial and trial by jury. And I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. Basically, it was a trial by jury. Now it's a jury trial where the jury's neutered. There's only 6 of them. They're cut in half, and they're not allowed to. They're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so, those are your two options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
No.
Well,
I mean, you're under you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to, let you know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No, absolutely not. I don't know why you would think that. That's completely not true.
No.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because Washington.
Well, the city of Tumwater in this case, remember we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they can still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney or have one with you or go it alone?
I'm not sure I need an attorney at this point because we'll have to see.
So again, that's a binary choice. So then from that, I can tell you you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
Just look at my record.
That's again, I can see your record, but that none of it tells me whether or not you've done a trial by yourself before.
I just see conviction, conviction, conviction. That's all we can see here.
So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So
Jackie could get him off for sure. She'd do a great job. Jury'd be like, not guilty all day long.
Then I'm going to talk, and then we're going to set a date, and then we'll conclude the hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution, at Article 1, Section 1, states that when the state is a party, which is this case, excuse me. Let me get the license. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.
So again, I'm going to speak for a few minutes, and then I'm going to turn it back to you, and we're going to set a date here. And again, I don't. First of all, this case is headed for trial. And again, it doesn't appear that you're interested in having an attorney appointed to represent you, so you'll be going it alone. When you have the constitutional right to do that, but you need to know that you're not an attorney. Apparently, you have very low opinion of attorneys, generally, and a very low opinion of the system itself. Could you tell Mr.
I have no problem with the law.
Hang on, let me finish. I'm not done yet. The city of Tumwater is going to be represented, and I know you don't like that term either, by an attorney. That attorney is trained in the rules of evidence, trained in the rules of procedure, been through trial many times. And again, I don't know whether you have or not. And so they are experienced in the rules of evidence, which is important. You spoke disparagingly of the rules of evidence earlier. And they have training in that, which again is important. And I'm going to assume you don't. And many of the things that you've talked about, you're incorrect on. Unfortunately, you're just incorrect about some things. And so you're going to be at a big disadvantage when you go to trial without an attorney going it alone. Do you understand this?
Isn't it the prosecutor's job to decide whether I'm wrong on issues? You're supposed to be neutral. The prosecutor hasn't even argued against me, and you're already saying that I'm wrong.
No, I'm trying to, believe it or not, and you probably won't. I'm actually trying to help you, let you know that this is just the way things are going. This is the way that this will happen. I'm not siding with the prosecutor. I'm just saying that this is what, and it's not the prosecutor's job really to decide what the prosecutor and defense, they disagree all the time on what the law is or what should be. And then I'm the one who gets to decide one way or the other. But some of the things that you're saying are so outside the norm that I don't need to hear from them. And I'm trying to let you know that what you think is going to happen and what you think the way things work is simply just not correct. And, I'll go back to that fundamental, I can't speak to the way juries were back in the 19th century. I just know how they are now. And I know that the jury's job in the cases of this sort is to find facts. That's what it is. And the judge is going to instruct them on the law. That's how it is. And the judge is going to determine what's going to be admissible or what's not. And that's just the way the trial is going to go. And I'm trying to let you know that is just to give you advance warning. So when you're in the middle of a trial saying, hey, what's going on here? You just at least have an idea of what's coming. That's all I'm trying to do. And I want to make sure that if you go to trial alone, you're going in with open eyes, understanding that you're at a fairly huge disadvantage. And so, but knowing all that, that's still the avenue you want to take.
You said the jury's job is to decide the facts, but there's no facts to decide because I'm acknowledging all the facts. I'm acknowledging all the facts. I'm not going to challenge them. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about. My issue is the law. And I'm not saying the law is wrong. It's a question of whether the law, this particular law that I'm charged under, applies to me, whether I'm a person within the meaning of the statute. Now, the jurors are taxed to pay legislators to make up laws for their benefit, yet they're not allowed to know what the laws are. Don't you think there's something wrong with that?
I'll give him this. He knows his argument. It's just crazy.
Well, I guess my response to that is, I think most people are aware that when you get behind the wheel of an automobile and conduct it in traffic, you need a license.
I've got a prank call.
And there are certain things that can happen that can get your license suspended. I think most.
We have to pause. Hello? Hello?
Hello.
Hello?
Are you still here?
I need a person on the line. I can't talk to a robot.
People know that.
Well, my position is I never had a license, never applied for a license, and I was not engaged in traffic. I was engaged in travel. Traffic is going to be the issue at this trial. And
well, then it'll be up to the jury it'll be jury determined whether you were in traffic or traveling. That's
excellent.
And the issue that you said, well, I never had a license, so it couldn't be suspended. I've seen people try this before, and I've never seen it work.
License.
And so here's what we're going to have. Hang on just a second. Here's what we're going to do today. So right now, trial is set for October 29th and 30th. Jury confirmation is set for October 22nd. You said you had a motion you want to bring. You can, that'll be heard on, what do we do? Yeah.
That motion hearing should be a blast.
That'll be heard on October 20th. You need to have that filed in writing by October 6th. And the state will have the response filed by October 13th.
Your Honor, if we could please request the defendant's email address so that the response motion can be sent to him as he's not per se.
Did you hear that, Mr. Blatt?
Not really.
They want it because so you're going to file something, and they're going to see it. They should have the opportunity to respond to it, and they want to get their response to you, and they want to do that through email.
That's fine.
So what is your email?
LeonSBlatt@yahoo.com.
Oops.
Leon.
Sorry.
S as in Sam.
My bad.
BLATT.
I meant to edit that out.
Did you get that?
I did, thank you.
My apologies.
All right, Mr. Blatt, I think that's it for today. And then at that particular time, the judge, whether it's me, whether it's one of the other judges here, I don't know.
Don't reach out to him, please.
How many judges work in this court that could be on this case?
Oh, we've got a few.
Four.
Okay. Can I have their names?
Sure. There's Kayla Wilcox.
Yeah, I hope it's her.
Brett Buckley.
He's great.
You already know my name.
Mm-hmm.
And then there's a commissioner named Paul Wool. It's all on the district court website. You can just go look at it.
All good people.
Okay. Thank you.
And my guess is that judge, whoever hears the motion, is probably going to have a conversation with you again, or at least try to, about the concept of representing yourself and the disadvantage. And again, I know you hate that word. I'm sorry if that offends you in some way, but or going to trial alone without the assistance of an attorney. That's just.
I never expressed hate for any statute or attorney or wording or the.
I don't say that. Again, I'm not suggesting you are. I think that, or if I did use that term, I apologize. I just think that, I'm spending a lot of time with this because I just think you're
wrong.
You're under some misunderstandings of a lot of real basic points. And, in terms of we're here in district court, the state of Washington, you want to talk a little constitutional law, state of Washington Constitution sets superior courts of courts of records. It's also in the Constitution that they can set and create such inferior courts as, by statute through the legislature. The legislature has done that. They have established this level of court through Chapter 3 in the Revised Code of Washington, if you want to look there. There's also a mechanism in place where district courts can contract with municipalities to provide court services. All this stuff has been litigated through the Court of Appeals and the Washington State Supreme Court. And again, it's just pretty standard stuff. And I've tried to spend some time explaining it to you. Unfortunately, I don't think I've been very successful. I'm sorry about that. I wish I was more successful, but you can research all that out. And I guess when you talk about one thing I will go back to that I should have said earlier, when you say the jury, you want to argue the law to the jury and shouldn't they know the law and so forth. A lot of that happens in the Court of Appeals and the Washington State Supreme Court. Again, I'll instruct the jury or whoever the judge is, whether it's me or one of my colleagues, will instruct the jury on the law.
All his colleagues are
the jury
great.
will decide the facts and then apply the law as I instruct them to it. Now, if I'm wrong about the law and you turn out to be right, All that's handled at the appellate level. You would file an appeal if you're convicted, and then you would, the court at first Superior Court would look at it and see if I made a mistake on the law, then, or you're right on the law, and if then it keeps going up all the way to the Court of Appeals, and then eventually to the Washington State Supreme Court, all they may or may not choose to take it. And so that's where the issues of law are decided.
Everything you just said about the evolution of the law is true. However, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary for a free state. That's what it says. So that means we eventually get so convoluted to oppress citizens of the state that we have to go back to fundamental principles.
Right. And again, I do want to address your last thing, you know, in terms of oppression. Again, let's remember what we're talking about here, and that is your license was suspended and you were alleged to have been driving. I know you have to say, well, you were traveling or whatever, and that's just, again, the only issue is, were you conducting an automobile and was your license suspended? And that's it. That's what this case is all about.
An automobile is different from a motor vehicle, and I believe the statute refers to motor vehicles. Motor vehicles encompass a lot of things. A motor vehicle can be a motorcycle, it can be an automobile, it can be, so, and I think that that's generally pretty accepted that an automobile is a motor vehicle. No, a motor vehicle.
I believe that it is.
A motor vehicle
unless it runs by, unless it's the Flintstones where they just run on the ground, then it's not a motor vehicle, but I'm joking, perhaps I shouldn't be.
A motor vehicle is a specific legal term in commerce. It's a business machine, like a truck, a taxi, or a bus that makes its business on the publicly funded roadways, which it does not have a right to do. A person
again, in Washington, and again, a motor vehicle includes a car. It does. And again, where do you get your driver's license? You go to the Department of Motor Vehicles, the DMV. That's where you get a driver's license for cars. And so it makes sense that, and again, I don't want to, we're going down a rabbit hole that was really not productive for either one of us, frankly. But, and again, I will just tell you that a motor vehicle includes automobiles within the terms of this statute in this state. It just does. And you can argue
I'll address this in my
otherwise, but you're not going to be successful.
I'll address this in my briefs and my motions, but of course the prosecutor and you will just pretend like you haven't even read it, like it. I've been through this many times.
I'm going to stop you again. I won't speak for the prosecutor, but if it's me, I'll read it. I'll read all of it.
But my experience has been, I'm sorry to say, to accuse you, but my experience has been that judges will just pretend that they haven't read it. They'll say, I've read it and I found it's not correct. But they never talk about the issues.
Again, I don't want to talk about things that haven't even happened yet. So maybe it'll be me, and then we'll see what happens. But do you know when you need to get your brief due?
By October 6th. October 6th, and the response by October 13th.
And we'll all reconvene on October 20th and hash it all out. Whether it's me or one of my colleagues, I don't know.
Okay.
That'll conclude the hearing for today.
Thank you.
You're welcome.
You're welcome. You can go now.
So Mr. Lease was on. You're free to go.
Yep, go.
All right, I'm going.
Go.
Get out. He might have been called by his attorney.
Yeah, get out. All right. He's going to address it in his brief. Hopefully he understands what that means. I hope he understands what it means to address it in his briefs. Otherwise, we can't follow this case. Just saying. I have my limits. So he is jumping to conclusions. He comes out and says, I know what's going to happen. You're going to read this and you're going to pretend you read it and say, I read it and it's bogus. But you don't ever address the merits of the argument. That's what you need to do. Want to read that brief, you must get it. It's going to be available. It's going to be out there. You know it is. All right. We are still in verdict watch, and it looks a little something like this. Let's see if I can get the timer on the screen. Box 3 is going to be... Ooh. Fire truck outside the house. Let's turn off box 1. We are 46 minutes into deliberation. For those who are counting, we anticipate that they probably won't get more than a couple hours of deliberation time tonight, which means we haven't heard from the judge if he's going to let the jury go till 8, 9 o'clock tonight. Sometimes we hear that. I don't think he will. It's Florida. People want to go home. They want to go home. So give them a couple hours tonight. And you sent something else, Josh? Somebody sent me a Supreme Court ruling on Leonard Blatt. Did he win that one? I haven't had time to even look at it. It would be curious if he's won a couple of these. Maybe just wearing people down. Okay. Oh, Judge McNally. McNally is great. Okay. Hold on 1 second. Let's jump really quickly. I need to turn this one on over here so I can monitor everything. Okay. That one's ready. And now Judge McNally. Here we come. What's the date on this one, Josh? This was 2 days ago.
Yep, I see it now. Let me get you with prosecutor.
Whoa. That was super, super loud. Not what we needed. Give me a second to find the right one. Length of time is 1:51:16. All right, here we go. You guys seeing this? Nope. Yes, okay. Another one from Josh. This is Judge Dad, one of our favorite judges. Incredible voice, too.
All right. 33rd court down session. I will Mike King preside.
Seat, please.
I'm going to have to move somewhere else.
Philip Trofibio versus Mariah Stennett, 2502959. Lisa. Lisa, you out there?
Yeah, I'm here.
Well. Happy birthday.
Thank you.
Just happens to be a big one, too.
Yeah, it does.
Watching a show and somebody said, you know, when you reach 50, you're reasonably certain that your life is half over. So I'll just leave you with that thought as we go on.
Oh, well, thanks. I feel much better about it.
Happy birthday, kid.
Thanks.
All right, Ms. Stennett, your name? This is 2502959. Trofibio versus Stennett. Ma'am, your name?
My name is Mariah Stennett.
Mr. Trofibio, your name, sir?
Philip Trofibio.
All right, ma'am, how did you come with funding?
Is this the right one?
So I am getting a partial of $2,399 from my MDHS application. And then the September balance of $1,100.
This
I
is
will
not
have.
the right one. Hold on, we have to skip ahead to 21 minutes. It's fun to watch this, but this is just a civil suit that's not interesting. 16, 17, 18, 19, 20, 21 is where we're going to start. So right here.
Burnett.
Yes, Your Honor. That would then equal 1096.91. My client is saying that there is $1,100.77 due and owing. So it's a discrepancy of about $4 and just under 20 cents. So if
I'll give you the judgment for 1,096.91.
That's fine, Your Honor.
You guys agree that you owe that at least?
Yes.
Writ date will be September 12th, so you have to pay by September 12th, okay, you guys?
Okay, thank you.
Do you understand?
Yes.
All right, so you got to pay him $109,691 by the 12th. So long as you do that, no writ will issue. But I am giving him a judgment after hearing. Okay?
Okay, thank you.
Your Honor. All right, have a good day. Thank you. Bridgewood versus Stephanie Murphy.
This is the one we want.
2503298 LT.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
All right, Ms. Murphy, good morning. Your name? Ms. Murphy, come on up here and tell me your name, please.
Well, my name is Beth Murphy. I'm a daughter.
Your name?
Stephanie Murphy.
I know, I remember. I got it. You can't.
Come over here. I apologize. We were here last week.
I know. I just can't let you represent us. Ms. Murphy, tell me your name, please.
Stephanie Ann Murphy.
All right, what do you think is owed on this one? State your appearance, Mr. Burns.
Yes, good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff. We're showing rent to retain of $2,593, costs in the total of $191.11 for a total due and owing of $2,784.11.
Do you agree that you owe that amount, Ms. Murphy? I can't let you represent
I know, but
her.
she has Alzheimer's. I should have told you that last
You got to get a lawyer. You got to get a lawyer. I just can't, I cannot let you do that.
All right.
Was another payment made that makes this less than $27.84? No? I'm asking you.
Me?
Yeah.
No.
Okay, so she agrees that she owes that amount, right?
Well, we haven't been living there. She hasn't been living there since like late May, early June because of bed bugs. We were forced out. She was forced out of there because of bed bugs. Can't stay there. I was paying. I handled her. I handled her bank account.
Did you turn over the key?
Yeah. I spent the entire summer cleaning out that place, throwing everything out for her.
All right, let's slow down. Let's slow down. All right. Department manager, your name?
Ginger Pelk.
Did they move out?
I have not received any keys from them.
They're on the counter. Okay.
Well,
they're on the counter?
Did you guys have a complaint of bed bugs?
Yes.
Ma'am.
Sorry. I'll let her and Tim Murphy talk.
Did you have a complaint of bed bugs?
Yes.
Who said yes? I'm asking you guys. Come on, just
Your
tell
Honor,
me.
Your Honor, I have no knowledge of it.
I'm talking to the Bridgewood's manager here. I'm asking her.
I thought you were talking to them.
No,
yes,
I'm talking.
They did have bed bugs. I found out because they told the neighbor, had it treated, and she said, well, I haven't been living there fully because of the bed bugs, but we've not received any keys. We've treated the apartment. There is a co-signer also on the account, and I tried calling him too, and no response from him.
Who's him?
I'm sorry?
Who's the co-owner? I mean, the co-lessee?
It is the father. So it would be Stephanie's, I believe, ex-husband.
Tim Murphy.
Tim Murphy, come on here.
Tim, where you at?
Jeez. Tim Murphy, you got to come up here.
He's on Zoom.
I'm on.
You got to start your video.
Okay, I'm on.
All right, I'm going to ask you to take your head off and tell me your name.
Timothy Murphy.
When did you leave there?
I never lived there. I was co-signed it because Stephanie's income from Social Security wasn't enough to cover, so I added my name to the co-signing it so they could afford the apartment.
You didn't add him as a party, Mr. Burns.
Your Honor, if I may speak to that, I'm looking at the lease right now. I'm not seeing Tim Murphy as a co-signee. I'm seeing, at least on the lease that is dated beginning October 14th, 2024 to October 31st, 2025. The only signatory on the lease is a Ms. Stephanie Murphy.
All right. Okay.
Well, I did sign it, though.
Slow down. You did or didn't?
I did. Sure. Ginger knows that.
There is a separate form that our guarantors signed. They're not on the original lease. They signed an addendum to the lease that they are co-signing.
All right. So we have a problem here. Doesn't look like you have all your parties in the case. And
Your Honor, I think we can resolve this. If they're indicating that they haven't lived there and the keys are on the counter and they don't intend to retake possession of the premises, then this case can be resolved by my client simply receiving the keys from the defendants. It sounds like they don't intend on living there in the future. And rather than going too far into the weeds with this, if my client can just receive possession of the premises back, I think we can have this case resolved.
Stephanie, you need to listen to me. Okay? They are offering you, and if you don't understand something I'm telling you, I want you to put your hand up and I'll start over. Fair? They are offering to enter into a consent order of dismissal where there will be no judgment entered, and you can turn over the keys by, let's say, tomorrow at 4:30. And if you do, that the case will remain dismissed. Is that agreeable with you?
Yes.
So, counsel, will you prepare a consent order of dismissal, no judgment, and say the case is dismissed with prejudice? However, defendant shall turn over the key to the property and vacate no later than September 3 at 4 o'clock.
Your Honor, I have no, I'm sorry.
You are.
I'll wait for the court to be done. I apologize, Your Honor.
That's all right. I'm used to being interrupted. Case will remain dismissed with prejudice so long as defendant turns over the keys.
I didn't know you could do that. Dismiss the case.
Is that fair, Mr. Burns?
Your Honor, I have no problem with those terms, but I can't dismiss it with prejudice, but I'd be willing to do everything else. I have no problem
You're
doing
not going to turn around and sue him for rent, right?
I can't speak to that, Your Honor. I mean,
Well, I thought you just said you were going to dismiss it if they turn the keys over. If not, we're going to have the battle now.
And Your Honor, I understand that. My
You understand
client,
what I'm saying? Because I don't know that they owe you anything if the bed bugs were that bad and they haven't been in there.
But
so why don't you go in a breakout room and talk to the apartment manager? Because it's not fair to them to have them turn the key over and then they have you start a lawsuit against them.
Your Honor, I don't want to
think I'm wrong. It's okay, but I'm not going to do that otherwise. It's not fair to them.
Let me ask my client this. Ginger, would you be willing to dismiss the case with prejudice?
And an indication that no money judge will be pursued for past due rent, period.
Yes, but I can't make that decision, but I'm going to tell you my corporate office will go after them for rent. The bed bugs were not caused by us.
Oh, then that's fine. We'll just adjourn it a week. You're going to have to get a lawyer, Stephanie. If you're going to fight this on a bed bug issue, you're going to have to get a lawyer. Your daughter cannot represent you.
Okay.
That's what I'll do. I'll adjourn it 1 week and we'll set it for trial. Everybody has to come in. I mean, it makes sense. Did you not ever tell the manager you were leaving?
Me?
No, I'm talking to the party here.
Yeah. Okay.
Did you ever tell the manager that you were leaving, that there were bed bugs on the property?
Yeah, they.
Hang on, ma'am. Talk to me. I don't want to be interrupted over here. Did you ever tell the manager, either in writing or in a phone call?
Emanation.
Why am I getting interrupted here? I'm not.
I muted him, Judge.
What's that?
I muted him. He's just talking.
Thank you. I want to know if you ever told the manager or wrote the manager and said, we got bed bugs, we're moving out.
Yes, they were aware of it.
You told them, answer my question. Did you? Okay, you got to step back, young lady. I cannot let you do this. Stephanie, stay right here. Just talk to me. I don't bite. I just want to know if you told the manager that you were leaving and that there was a bed bug issue.
They knew about the bed bugs.
I didn't ask you
They're
that.
right next door to us. And I had told them and showed.
Told, who's them?
The next door neighbors, but the people we rent from.
I'm
Our
sorry?
neighbors, our next door neighbors.
You told your next door neighbors?
Well, yeah,
Did you tell the manager?
she is the manager.
Do you live next door to her?
I do not. I found out they had bed bugs because they told their neighbor that they weren't staying in the apartment because they had bed bugs. That is how I found out.
How did you find that out?
Oh, I would have to go back through the emails. I was not under.
How did you find that out?
Hold on. I'd have to go back through my.
Take your time.
Okay, so the party in the courtroom has Alzheimer's. I don't think the judge can legally proceed knowing that she
What
has
day,
medical
Stephanie,
condition.
did you move out of there? Do you know?
It was, probably 2 weeks ago.
2 weeks ago?
No.
Ma'am, sit in the back now. Next move you say, I'm sending you out of the courtroom. Sit in the back.
She's
my daughter and she lives with me.
I know, but I can't allow her to represent you.
Can I say something, Judge?
No, you can't. You're not even a party either. Stephanie, I want you to look at me. If you're feeling pressured, tell me, Judge, I'm feeling pressured, and I'll let you go hire a lawyer and come back next week. Okay? Do you remember when you told, so you're saying you stayed in there until mid-August?
Yes.
When did you have it treated for bed bugs? No, I'm asking you, the manager again. I did not catch your name, so I've got to ask you again. What is your name?
My name?
No, the manager. Are you
I'm
listening?
sorry. I'm looking at her account. My name is Ginger.
Ginger what?
This is so bad.
Pelk?
Yes.
PELC?
Correct.
All right. When did you have the bed bugs treated, and when were you notified by the neighbors or Ms. Murphy or anybody else on the planet that they'd vacated the property?
Yeah, I was trying to pull up the emails, her account. I can tell you they were charged for the bed bugs on July 1st. I charged them for the treatment.
Why'd they get charged?
Because they have the bed bugs. Nobody else had the bed bugs.
Okay.
Our normal extermination does not cover bed bugs.
Okay, July 1 is when that happened, right?
Yeah, that's when they got charged. They paid July's rent too.
So all we're talking about here is half of August rent or all of August rent, right?
Yes, Your Honor. Yes.
Well, man, when were the bed bugs treated?
I'm trying to pull up that right now. Bear with me. I'm sorry.
You lived there after the bed bugs were treated, Stephanie? Stephanie, look at me.
Oh.
Did you treat the bed, did you remain in the property after the bed bugs were treated?
Yes.
For how long?
I don't know, maybe a couple of weeks. It wasn't very long.
So I pulled up the addendum to the bed bugs. So they were charged July 1st for the bed bugs, but because they left their cats in there while they were not living there, and they didn't get the clothes properly prepped, we did not end up treating until July 29th because they moved out and left 2 cats in there.
Wait a second.
You charged
You
them?
just got done telling me that they left 2 weeks ago. When do you think they left?
They weren't staying there because of the bed bugs, but there was still clothes in the bedroom, mattresses, couch, kitchen table, and 2 cats. I know the cats they had to remove for us to treat on July 29th.
When did you
But
think
I
they
have
left?
not heard from them.
All right,
They
Stephanie.
told me they were not
I would
staying there
like to come
because
up
of.
here and I'm going to ask, Mrs. Murphy, what's your name again? Beth what?
Murphy?
Come on up here. Now, I'm going to tell you, I'm going to ask you questions or two because I'm going to let you be kind of a witness here. But if you answer out loud without me directing you again or without me addressing you again, I'm sending you out the hallway. Do we understand one another?
Yes.
All right. Now you can tell me when. Were you living with your mother
Yes.
until she moved out?
Well, we both moved out.
I understand. Okay. When was that?
Late May, early June.
How did the cat survive?
Hang on. You're saying you left late May, early June.
Well, you guys not living there.
She's saying, Stephanie told me 2 weeks ago, which would make it around August the 17th or 18th.
She has Alzheimer's.
They say you had cats in there after they knew of the bedbug problem in July. Is that true or false?
Cats, yes.
Well, the cats were still there, right?
Cats were still there.
Well, then you didn't move out. You never turned your keys over. You still were occupying the property. I'm just amazed that you guys didn't communicate with the manager. I think a lot of this could have been avoided. You don't just tell your neighbors, I'm moving out, I got bed bugs. And leave cats there and then come back and I'm not keeping you up, am I?
Sir.
Sir, I'm not keeping you up, am I?
No.
Okay.
Big yawn.
I don't want to keep you up.
No.
Okay, all right.
He's like, oh.
Mr. Burns, can you not just go in a room and talk to this Stephanie Murphy with her daughter there and see if you can't resolve this?
I'm willing to do that, Your Honor. I do have one other matter I'm trying to wrap up in a different court. So if the court puts us in a breakout room, I'm willing to address these things. I just want to let you
Put
know.
you guys in a breakout room with Mr. Burns. Stephanie really has to do the talking. It looks like you got to handle this better. You can't just walk out of there, leave cats in there. Technically, you still occupy the property.
Right.
You didn't turn the keys over. Was this still during the lease period, Ms. Pelk?
Yes, they're still in a current lease until the end of October.
Did you guys stop and think about that before you started leaving? You're going to get stuck paying this rent again. You can't just move out. I'm just telling you. Where do you live now, Ms. Murphy? Stephanie, where do you live?
I'm still there.
I get Alzheimer's. I understand Alzheimer's. I cannot let you represent her. Ms. Murphy, talk to me. You just explained to me that you left 2 weeks ago, right?
No, no. I did not leave 2 weeks ago. I left recently.
What's recent?
Yeah.
Okay, so you've been in there the whole time.
Yeah.
I'm going to let you guys go talk to Mr. Burns. He has another courtroom to go to. My court officer's going to take you to a computer and you can Zoom with Mr. Burns. He'll explain it to you and we'll go from there, okay? I'll pass this case. Thank you. Nelson Ronaldo Pineda, Velasco, 25M7712.
We want to see the resolution on this to see what happens. 1 hour, 12 minutes. I realize that the judge, it's frustrating, but the judge has the law that he has to follow. He can't allow certain things to happen.
As soon as he posts, you go down and get your notices. Thank you both very much. Have a good day. All right, now, I need, wait 1 second. What did they do? Bridgewood versus Stephanie Murphy, 2503298.
Good afternoon, Your Honor. Again, Michael Burns, P87855 on behalf of plaintiff.
Where's Stephanie Murphy at?
They are in the hallway, Your Honor. They should be on the way in soon, if not in the courtroom already.
Is this resolved?
Yes, Your Honor. We're doing a conditional dismissal.
Okay. All right. Just wait till they come in. And we'll get rid of that one.
Bailiff's going to go get him.
Just go back to the podium.
Just her?
Yep.
Come on up here, ma'am. Ms. Murphy, come on up. Bridgewood versus Stephanie Murphy.
Right to the podium.
2503298.
Go this way, come
All right. Your name?
Stephanie Murphy.
on. Right there.
Stay at that podium there if you would, okay?
Right over here.
Speak into that microphone. See that microphone?
Yes.
I need you to speak into that, okay? Tell me your name.
Stephanie Murphy.
All right. I need your name again, Mr. Burns, and then Ms. Belk's appearance again, and we'll go from there.
Thank you, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Help, Bridgewood manager.
All right. Just if I call on you again, you have to speak more directly into the microphone, Ms. Pelk. We're kind of getting some of your words, not others. What are the terms of this conditional dismissal, counsel?
Your Honor, the terms of the conditional dismissal are that the case will be dismissed pending the defendant turning in keys to the unit by tomorrow at 4:30 p.m. My client would be dismissing this case without prejudice. I've informed Ms. Murphy that my client does wish to recover the past due amount because the tenancy had continued. So we would be dismissing the case without prejudice as long as the keys are turned in by 4:30 tomorrow. I would just ask that the court confirm with Ms. Murphy.
Ms. Murphy, I want you to listen.
I am listening.
Okay. They're going to dismiss this case without prejudice, meaning they can bring the case again, as long as you turn in the keys by 4 p.m. tomorrow.
Okay.
Do you understand that?
Yes, I do.
Do you agree to that?
Yes, I do.
Do you understand they're going to turn around and sue you for non-payment of rent, though? They're going to turn around and sue you for non-payment of rent for, I heard that you paid July, so at least for August and probably September. Do you understand that?
Yes.
Do you still wish to settle under those terms and conditions?
Yes.
And Ms. Murphy in the back, I just want to make sure, I want to extend this courtesy. Does your mother understand everything I just said with her? You would have talked to her on Zoom with Mr. Burns.
She understands, but she won't remember it tomorrow
Okay.
or next week.
Okay. I wish I could have yeah, I get it. I'm sorry, ma'am. Do you understand though?
Yes, I do.
All right. September 3rd, turn that over by 4 p.m. They're going to turn around and sue you. You understand that, right?
Yes.
Do you have any questions for me?
No.
I sincerely wish you well, Miss Murphy. Ma'am, these are not my rules in the back. I have to comply with them though, okay?
Judge is
Good
bound
luck
by
to
the
you.
law.
Good luck to you both. And good luck to you, Ms. Pelk and Mr. Burns. Is that it for you, Mr. Burns?
Yes, Your Honor, it is, and I appreciate the court's patience and Ms. Murphy's patience, so thank you all.
No problem. Thank you very much. Mr. Cooper, you have a case out there, huh?
Okay,
I do, Judge.
We're going to bail on that now. Oh, that's a tough one to watch. Yeah, it's tough to see that, where you have a medical condition that really she should not be representing herself in court. The right thing to do would be to get a lawyer that could fight that, because that outcome is entirely in the landlord's favor, right? That's everything. We get the property back immediately tomorrow, and we're going to sue you for all the back money, and part of that's going to be included is the bed bug treatment and everything else. They're going to get everything out of that when they're with a lawyer with proper representation in front of the judge. That might have been argued differently, especially the bed bug situation, and even some of the back rent might have been negated or removed. But yeah, that's tough. Hurts to see that. All right, let's see if we can go back to Donna Adelson, see where we're at on that one. We are just watching the wall still. As far as that goes, we're looking at 1 hour and 16 minutes of deliberation so far. It is 5:30. Law doesn't have feelings. Yeah, it's the law. It hurts. Let's see. Josh, I'm not sure if I'm going to be able to get to this one. Pro se infraction calendar. Oh my goodness. Let's try it because we're still here on break. We'll keep monitoring down there in Tallahassee, but we'll jump here and take you back up to Thurston County, Washington, where there's another one Josh has for us. Oops, that was not it. That was some tennis star interview. We don't need that one. Sorry, I can barely see from back here. Thurston County District Court 1. And it is this one. The timer on this is what, Josh? Is it the whole thing? Didn't get a timer. Guy on the left. Court's still going, so this is a live one. Looking for a dude in a white shirt. I'll show you what we're looking at here. Oops, try that again. We're looking for a dude in a white shirt in court there in the top left-hand box. Possibly waiting for Josh to tell us what the timer is as well, which could be quicker. Nobody in court, nobody in court, nobody in court. Looks like they had a lunch break. I think we saw him come in there, enter the courtroom, but he hasn't taken a seat. Still not there. Oh, here we go. That's him.
Still count as points towards my license?
They don't do points in Washington. I mean, it would be there as a committed speeding ticket.
Okay.
You have a couple of speeding tickets, but not a lot. And so I don't know what that would do to your insurance. That's between you and your insurance.
Okay, thank you.
Sure. In 5 over, that's not.
I think they're about done.
And if you're worried about it, you can defer it. It costs you more money. It'd be 150. But if this happens again, that deferral's still eligible for you.
Of course, yeah.
But don't let it happen again.
No, it was an honest mistake. I didn't know.
All right, come on up. You can take that to the window.
Okay. And I just pay that right there at the window right there?
Yep.
Okay.
All right. Here's
and
the next
then Mr.
case.
Giorno. Thank you. Come on up.
This one
You're here on a
happened
couple
just
of
minutes
things.
ago.
No valid operator license, but with valid ID, and then a seatbelt ticket. So I guess we'll start with those are 2 things. And again, a valid ID, that's the same. You're free to go if you wish. Yeah, you can go ahead and just go line up at the window. You can stay if you want to. No one ever does when I make that comment, make that offer. But Mr. Giorno, like again, the license issue, that's a pretty cut and dried thing. You have a license now. It looks like you do. Looks like you got the license like 2 days later. And then, so how did you want to? So again, how did you want to proceed on the seatbelt ticket?
Well, I'd like to contest the hearing, Your Honor.
So you're contesting on this speeding ticket, but then mitigating on the valid
seatbelt issue.
Seatbelt ticket. I'm sorry. You're right. You're contesting the seatbelt ticket, but you're mitigating then the license issue?
I'm contesting it, Your Honor.
Okay. Okay. Could you raise your right hand, please?
Yes.
Okay.
You swear to affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down.
Hey, Garrett. No relation to me, by the way.
Seatbelt ticket first. What? Did you get a chance to review your police report?
I did.
Okay. Go ahead.
And I set forth a motion for discovery, and I had a couple of questions and.
Did you submit it? Give me just a moment. So you submitted a discovery request?
I did.
You did?
Yes.
Did you ever get anything?
I did. All I got was a printed tick the box return. I had two questions that weren't answered.
Okay, so what, give me just a minute.
Okay.
Garrett's just chilling back there in front of the wood-burning stove. Staying cozy and warm. Bottom right-hand corner is a live view of Tallahassee.
I hereby set forth a request for discovery concerning the above case.
Yes.
And then I also request any evidence that you're subject to the codes concerning this case. And you request any evidence that you're in any type of contract concerning this case.
Yes.
Okay. So the discovery typically is a police report, an affidavit or some sort that says what happened out there. Did you get that?
I got a tick the box.
Right. That's
print.
That's right. So that's the evidence there. And then on your, the codes, it should say on your infraction, where you were served with that, it has the, yeah, right there. You go look right next to there, they'll have the codes there.
Your Honor, I was asking for some evidence that subject to these codes, I got nothing from the prosecutor's office. I didn't get a reply to either.
Well, they don't have anything to that, about that, first of all. And secondly, I request evidence that you're in any type of contract concerning this case.
Yes.
There isn't any.
Right. So
that doesn't have anything, whether you're in a contract or not. I don't know why people make this argument to me. I really don't.
Okay.
But there's rules of the road. You need to comply with them. There's, you go on the freeway, you see all the people on I-5. None of those people have contracts to drive on the highway, but they're required to follow the rules of the road, including have a license and don't drive under the influence of alcohol, maintain the speed limit and all that sort of stuff. There is no contract of any sort. That's just the rules you got to follow. And that's been litigated quite, for a long period of time. And the absence of any sort of written contract or oral contract with anybody, I will tell you that that's not a winning argument. It's just not.
Okay, but returning to being subject to the codes, there was also no response from the prosecutor's office as far as being subject to these codes.
Well, again, anybody who drives on the road are subject to the rules of the road. I mean, they just are. You don't have and again, taking that away from the traffic, you're not allowed to rob a bank either. You're not allowed to assault people, but there's no, you just live under those codes. You don't have, no one ever came to you and said, hey, you're subject to the code that says you can't assault people. The same is true with driving. You have to be licensed. In order to be licensed, you have to take a test. You have to both driving and written. And then that when you choose to get on the road, you're subject to those, you're just subject to all the laws in the state, whether or not it's traffic or not.
I understand but there is no injured third party. You abide by the rules, no one gets injured.
That's and again, I've heard that too, and I have zero idea where that comes from, because that's just not true. I mean, like for example, then people could drive drunk as long as they didn't hit anybody, they're fine. But that's certainly not the case.
Well, that would be, that would be reckless driving.
And you can commit crimes without hurting individuals.
Watch Garrett's reaction.
I mean, just because no one got hurt, no harm, no foul might work in the NBA, but that's not in terms of
Garrett's
the rules of the road. You have to comply with them. So again, the issue, and again, I will tell you what the issue is they're very narrow, right? What you're charged with is not having a license, but without identification, or not having license, but with identification. And so that's it. I just make a determination. The police officer said in his report, you didn't have a license with you. And then it looks to me like you got one shortly thereafter. And that's, did you have a license when you were driving or not? That's the only inquiry. The second inquiry is, were you wearing your seatbelt or not? That's all there is to it. And so that's what I'm asked to decide. So I can swear you in and I'll hear from you. And then following that, I'll read the report and then I'll make a determination on those two issues, whether A, you were wearing a seatbelt, and 2, you were operating while you didn't have, without a valid license at the time. That's it. And you could mitigate, you could admit that, and then, well, the license ticket, that's an expensive ticket. And so again, if you want to think about what you want to do, I think Mr. McIntyre, I think, is probably taking a little bit more time than we thought. So I can take care of him if you want to think about what I'm saying. Maybe this is coming as news to you. I'll hear from Mr. McIntyre, and then I'll come back and hear from you. Mr. McIntyre, you can activate your microphone.
Yeah,
how did you wish to proceed here today? You're muted. Okay.
Yes, sir. Yes, Your Honor. I would just like to get a deferral.
Okay.
I'm not disputing with the officer. I did not have my seatbelt on. I just would like to apply for a deferral because this will be my 3rd ticket and I'll lose my license and I won't be able to drive it. And I use a company vehicle to work.
You can have one. This will be deferred. You can get on the Thurston County District Court website. It's $150 and you need to pay that within 90 days. And then there's a procedure how to go pay that, and you can certainly do that.
I'll pay it this week. I just don't want to lose my license.
You're free to go.
Thank you. Thank you, Your Honor.
Wow. You can buy your way out of a ticket? Not bad.
Wasn't matter end. We'll deal with it when we get back. So, Mr. Giorno, where are we at?
This is
I've got one last thing I want to say about the prosecutor's responsibilities. They're required to give you everything they have regarding this case. And this is all there is. Just that police report and the citation. So there's no, this isn't a speeding ticket. There's no speed measuring device. There's no pictures or anything like that or video. It's just the officer's report saying that you didn't have your license and that you didn't have a seatbelt. So what do you want to do here today?
Well, I had a seatbelt on and I would like to.
So if you want to contest it, then let me, I can't even remember now. Did I swear you in?
Not yet.
Yes.
Okay. So talk to me about the seatbelt.
No, you
didn't. The officer's report is fabricated hearsay. I say it's inadmissible hearsay, and I motion to strike because.
So hang on just a minute. Let me get the report up. How is it hearsay?
The officer's report is
Says
inadmissible
I admitted to. I did not. Of course not. And I would like to see the video. I'd like to cross-examine. There is no
video.
Okay.
And if you want to, you need to make a request to have the officer present in order to do that. If you want it, and then in the absence of having the officer present, I can decide it from the court rules are clear on that. I can rely on the report. I want to set it over for a period of time to most people ask for the officer to show up, hoping they won't, if you want my frank opinion. But if you want, I'll give you the benefit of setting this over to have so the trooper can appear if you wish to do that.
Well, I object to that, Your Honor, because I showed up today and it seems
But you need to, again, this is another example of you need to follow the rules. In order to have the trip, you have to provide a request for that in advance of the hearing. We never got the request.
Your Honor, I understand that it's the burden of proof is on the plaintiff.
True.
So the officer's not here.
That's
There's
true.
a failure to appear. So I can't cross-examine the officer.
But I don't
he
think
did say that it was videoed.
Well, they might not. They probably, again, on takes like this, we wouldn't have preserved that and sent it to the prosecutor's office. You didn't make the request to State Patrol to get that. You made a request to the prosecutor's office, what they had for the case.
Well, it's a little hard to discuss things with State Patrol.
What's that?
It's a little difficult to discuss issues with State Patrol when they are in a certain mode.
Okay. So what do you want to do here? Again, I'm still not too clear.
Well,
if you want to contest the seatbelt, we can do that. And then tell me what happened out there. Were you wearing your seatbelt? And if not, why not? And tell me what the misunderstanding with the officer is. Well, go ahead.
Well,
I'm going to end the poll right now.
Could not have seen what I was doing either way because he did a 180-degree wheel spin in the middle of the Elm Highway, where I've lived for 35 years.
You live on the highway?
I, as far as I know, had a valid driver's license and have always had a valid driver's license. So I contest that I don't have any evidence from the prosecutor's office. I don't have any witness to cross-examine.
You do have evidence from the prosecutor's office. You have that report.
This is a print, Your Honor.
I know what it is. I'm looking at the same thing.
I have one, the original.
At the bottom of it, you can say it was certified under penalty of perjury. And then there's the officer's signature on there.
Well,
give me just a minute. Give me just a minute here.
Okay.
So the poll is done. Let's see if I can get it to post. It's not posting. There we go. How long will the jury deliberate? 2 to 4 hours was 44%. 4 to 8 hours, 29%. 2 hours, less than 2 hours, 20%, which we're almost to. We're half an hour away from that. And a long weekend, 5%. That's with 1,700 votes. That looks like we're looking for tonight.
With regard to the officer not being here,
morning.
upon written demand of the defendant, at least 14 days before a contested hearing filed with the court and served in the office of the prosecuting attorney assigned to the court in which the infraction is filed, the prosecuting attorney shall at least 7 days before the court hearing provide you with a copy. That's not what I'm looking for. In a minute. Oh yeah. On earlier in that same rule, a request that an officer appear at a contested hearing pursuant to this rule shall be filed in a separate pleading, and it may be directed, and then someplace else in this rule, it says, in the absence of that request, the judge, me, can rely on the police reports. And that is a police report. Yes, it's short, but that's what we have. And again, that's, so, do you have anything else? Because I'm ready to rule on these cases, and again, I'll give you the opportunity to set this over and to have the trooper present if you wish.
I would do that.
You're here now. I don't have to, but I will give you that accommodation if you wish
I would
to
do it
take
because they
advantage
might
of
not
it.
show up and then it's dismissed.
So there's no prosecutor present, there's no witness present. Doesn't seem I'm allowed to have a fair trial. I believe, if I'm not mistaken, it is an adversarial court system.
Right.
We have two parties. There is no injured third party. I still don't get an opportunity to cross-examine, and they have failed by default to appear. So I don't see why this should continue on.
So they don't, the prosecutor doesn't need to. They're not required to. And the fact that they don't on these infractions, again, they rely on the report. And so, and that's just what they do. And sometimes they do that to their peril. You don't know how I'm gonna rule on these cases. And sometimes these reports are incomplete, or I don't know, you were here at 1:30, they didn't even file one. So the case was dismissed and the woman who was there just left. And that happens sometimes too. And so the rules allow for this sort of procedure. And like I say, I'm giving you the opportunity to have that trooper present if you want to take it. And so you've complained about, he's not here. And I've tried to explain to you that it's not, there's certain things you have to do to get him or her here. And you didn't do them, but I'm giving you the opportunity to set this over so you can speak with them if you wish. And it's entirely up to you.
Well, I'm here for the hearing. I mean, it's going to be a fair trial. I mean, you seem to be, arguing for the plaintiff, whereas
I don't mean to be doing that. I'm just trying to explain to you what the rules are. And in certain instances like these, they don't have to do things. And so I'm not saying about the sufficiency of the evidence. I'm not saying, well, you should be convicted or be found committed for this reason or for that reason. I'm not saying any of that. I'm just saying these are the rules for this sorts of procedure. And if you perceive that as me being on the side of a big argument against you, I'm sorry about that, but that's not what I'm trying to do.
Well, this print that the officer gave me, I did not and was not able to see who was in his vehicle. So I have no idea who printed that up. I have no idea. There is no personal signature on anything. And yet again, I'm here and showed up and they don't have a case. They're not here.
He's arguing the same point over and over.
Well,
I'm a little bit perplexed by that.
So here's what I'm prepared to do here today. With regard to, you have 2 infractions here, and with regard to you're correct. You've shown up. I've sworn you in. I've listened to you testify. With regard to the seatbelt ticket, I'll give you the benefit of the doubt. It will be a finding of not committed on the seatbelt ticket. However, with regard to the license, based on the report of the police report, combined with the fact that on your ADR, which I'm allowed to look at, it looks like you were issued a license 2 days after this. It will be a finding of committed with driving without the license.
Your Honor, I forgot to bring my old license in. You can't read the date on it. I mean, it's just,
okay, so again,
it sounds like an entrapment. It's not like the Department of Licensing sends you a notice because your license went in the laundry or whatever, you can't read it. And suddenly I'm just driving like normal, and it's like, oh, that's crazy. I couldn't even read it.
That's your problem.
And I'll bring it in.
I'm going to go back to, and I'm going to say this one last thing, and then I told you how I'm going to rule on these infractions, but I will respond to that in this manner. And that is, it's, again, when you get on the road, it's your responsibility to comply with the rules of the road. It just is. And part of that is it's your responsibility to make sure you're appropriately licensed. And I'm not seeing it. You're right. You didn't see that. I don't know what it looked like when it came out of the laundry, but that's going to be my ruling on this case. And so they'll be not committed on the seatbelt, and that'll be dismissed. It will be committed on the no valid operator license, and the fine is
bigger than seatbelt.
Since you got a license shortly thereafter, I will reduce the fine. I'll chop the fine in half.
He's winning. He's still mad, but he's winning.
But I got discovery.
The fine will be, and again, hang on just a second. The fine will be $280. And again, I tried to explain to you, that is the discovery, that police report, that's what it is.
But discovery did not say that I am subject to these codes.
Well, again, I tried to explain that to you too. When you choose to get on the road, you're subject to the rules of the road. You need to follow.
I object. This is not fair.
You can object and you can appeal if you wish also.
I will.
Okay.
I will. This is not fair.
You can give him a piece of paper. You can come up this and you can take this to the window.
You can appeal.
Set up payment arrangements, file your appeal, or whatever you wish to do. That's fine. You're certainly free to do that.
You're acting as a prosecutor, giving me a bill. I disagree. This is not fair. This is not a fair trial. They didn't show up. The onus and burden of proof is not on me.
They proved it through a report that they filed.
I'm not subject to these codes according to the prosecutor's office. So I'm not subject to a fine until we have a fair trial.
Okay.
Fair and impartial.
Okay, I've told you what I've ruled. I've tried to explain to you the rules of infraction hearings. They don't necessarily need to. Sometimes they choose to, sometimes they don't. They don't have to. They filed the police report. I can rely on that. The court rules allow that. I know you disagree with that, and that's...
the officer doesn't even have the decency to sign his own name.
And you can come and take this, and you can take that to the window and set up payment arrangements. Or if you want to refuse to pay it, it'll be an unpaid infraction. And I'm telling you what I've done here today, and that's that's going to be the hearing will be concluded.
You didn't offer me another option that you stated at the opening of this hearing. You didn't offer me a deferral.
I did offer you a deferral. You told me you were wanted to contest it.
Yep.
I mean, I clearly offered you a deferral. I thought I said that at the beginning. I went through all three options. And
at the beginning when everyone was present.
Yeah. And I told everybody what their options are. And then when they come to the table, they tell me what they want to do.
Yes.
And you
I was pursuing a line of contesting this.
Right. And that's what you did. And then I made my ruling. And I ruled against you, which is what happened here today.
You lost.
So you can come and get that or refuse to take it, whatever you wish to do. But this hearing will be concluded, and that'll be it for this hearing. And so I'm going to take it. We're going to move to, I think, everybody else on the
judge is like, I'm leaving now. You don't have to go home, but you
on the
can't
Zoom
stay here.
calls at 2:30. There's someone on a phone number there who's ending in 55293. What's your name?
I think he sounded like maybe possibly New Zealand.
On the telephone, what's your name? And then Mr. Pacheco? And Ms. Sato?
Yes, Your Honor.
All respectful. We're not with him.
Your Honor, this is Renee Johnson.
Hey, Renee.
What time are you scheduled to be here?
At 2. I've been here since 2.
You haven't been here since 2. So.
Well, it was right around that time.
Yeah, don't lie to the judge. He can see when you came in.
What time was it?
What time was it that I came in? These judges need to have just oodles of patience. Oodles and oodles of spare patience. All right, I think we're going to wrap things up for today. I think we're going to do that because we're still watching for the verdict. The verdict has not come in yet, but I'll keep an eye out on that. We will bring it to you if it happens. But we have a podcast tonight. We have a podcast, and I'm thinking that the verdict is not going to happen today, just the way it's going. It just looks like we'll get this for the rest of tonight. So on my hyperdeck, I can record for another 57 hours. So I'll have that rolling to make sure we don't miss anything on the hyperdeck for out of Tallahassee if something happens to bring you the verdict. But we are going to do the podcast at 8, and I've only got like 2 hours to get ready and make sure Thomas is also ready because I haven't done anything. So we're gonna wrap it up here for tonight. We would love it. We'd love it if you came and joined us tonight for the Not Relevant podcast. It's a lot of fun. It's more fun than some of the court cases we watched today for sure. And it's much better than the poking the eye with a sharp stick. So if that was the alternative, please be here at the podcast. It would be great. Cass, thanks for the kind words. Best creator ever. I like that. It's obviously a little more generous than I think I deserve, but awesome. Thank you. All right. We are wrapping up tonight at 8 p.m. Please join us on this channel. Try to pop in later. Awesome. Good night, all. Thanks to the amazing mods. Thanks to all of you who joined us today. It's a lot of fun. We've made it to the end of the case. Sometimes it feels like we'll never get there, but we did. The jury has this one. It's in their capable hands. I think they will be able to reach a verdict. It's just a question of when. So we don't know how long the jury can deliberate. I'm watching the social media. Trust me, if word breaks that they're coming back, we'll come back and cover it. Okay. Otherwise, we're gonna have the podcast, and we'll keep an eye on that too. So we'll find out when they end. Probably on the podcast, we'll tell you what time the jury went home. That's what I anticipate. But I imagine the judge doesn't work all night. We'll see. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again 8 p.m. tonight on this channel, the Not Relevant Podcast. Please join us. It's going to be great. We're going to give away memberships at the very beginning. So if you would like to win one of those, just be there early. Click the like button like you've done on this live stream. And sit tight and chat. Say hi to your friends and see what happens. Could be you. You guys have a good one. We'll see you in a little bit. Bye.
Thank you, sir. You're my new best friend.